And my lord, this matter, my lord,
You have mentioned, but it is not appearing.
not appearing, my lord, proceeding discuss, my lord. With 20th, my bench is sitting, my lord.
Appear করছে না কেন দেখবেন?
Lordship with us is proceeding discuss.
We will check up why it is not appearing.
Lordship. Sorry,
জলপাইগুড়ি?
what principal bench?
No, this is mentioned for the first time before us.
No, second, third time, my lord, I mentioned.
Third time?
Yes, my lord, this is third time. Twice, I mentioned twice. And transferred to principal bench, my lord.
Anyway, we don't. জলপাইগুড়ি matter, if it was mentioned, it should have been there on the list. দিয়ে দেবেন জলপাইগুড়ি যেদিন নেক্সট থাকবে আমাদের।
আমার সিটিং tomorrow, my lord. Lordship is sitting.
কালকে আমাদের বেঞ্চ আছে জলপাইগুড়ি? ফাইল যদি থাকে তাহলে if it comes it will be on the list. Yes.
To mention one matter, my lord, inclusion in the list for hearing, my lord.
Yes.
Your Lordship, may I mention one matter? This is an appeal out of a matrimonial suit, Your Lordship, for inclusion.
My lord, I am mentioning for application, this on the basis of the last order.
Yes, application please hand over. Yes.
Okay,
My
thank you.
lord, I had mentioned this, my lord, last week. The lordship had allowed, my lord, the mentioning, my lord, it's an application. But I am moving it, my lord, for stay of the order which has been passed. My lord,
You
it's a
hand
group
it
one
over
matter.
again. Yes.
My lord, seeking leave to file without certified
Yes.
copy. And leave to appeal also, Lordship.
Leave to?
Leave to appeal, Lordship. I am not a party in the
Leave to appeal has to be by way of an application.
Yes, Your Lordship. I have that application, Lordship.
Leave is granted to file without the certified copy.
Yes, Your
Leave to
Lordship.
appeal you have to mention.
Okay.
The application has
after
to be
filing the
after
memorandum,
filing it
I will
mention.
get full to Your Lordship.
জলপাইগুড়ি matter, yes.
Lordship, I am led by my senior, Mr. Saurabh Ganguly.
Yes.
He's on
Yes.
his legs in another
In
court.
view of the
so-
above, DR number 04 of 2024 is disposed of and CRA DB 56 of 2024 is allowed in part, thereby affirming the conviction of the appellant on all counts of offence. However, the death sentence of the appellant is commuted to life imprisonment without early remission, at least for a period of 20 years and without parole for 20 years, unless extreme exigency is established by the appellant. The sentences of rigorous imprisonment of 7 years and rigorous imprisonment for 10 years for the offences under sections 363 and 366 respectively of the Indian Penal Code shall run concurrently, meaning thereby that out of the life sentence, 10 years will be spent by the appellant in rigorous imprisonment. In view of the poor financial condition of the appellant and his family, the fine of rupees 5,000 each for the offences under 363 and 366 of the IPC are set aside, along with the consequential additional periods of imprisonment in default of payment of such amount. The actual period already spent by the appellant in custody shall be set off from the period of 20 years, during which no early remission or parole of the appellant shall be considered. The department shall immediately communicate this judgment to the superintendent of the correctional home where the appellant is now housed, who shall ensure that a copy of the same is provided to the appellant and the gist of the same is read over and explained to the appellant at the earliest in his mother tongue. A copy of the judgment shall immediately be sent by the department to the trial court as well. এইটা immediately জলপাইগুড়ি থেকে হোক কি আমাদের এখান থেকে হোক এনশিওর করবেন যাতে তাড়াতাড়ি ফাইলটা চলে যায়, অর্ডারটা যেন ইমিডিয়েটলি কমিউনিকেট হয়ে যায়। ঠিক আছে?
Grateful,
I'm grateful, Lordship.
কেন কনভিক্টের লাইফ সেন্টেন্সটা মানে ডেথ সেন্টেন্সটা লাইফে হয়েছে তো ওর ইমিডিয়েটলি জানা দরকার, কমিউনিকেশনটা যেন ইমিডিয়েট হয়।
Grateful.
থ্যাংক ইউ। অলরাইট।
My lord, Mr. Siddhartha Banerjee is in courtroom number 26. Kindly short pass over, my lord.
Lord, he had yesterday, my lord, we have the Supreme Court's order.
Please hand it over to us.
My lord, he's coming. He's on his legs.
কখন আসবে?
26 আছে। একটু দাঁড়িয়ে
তাহলে আরম্ভ করছি তো কতক্ষণ আসুক?
একটু দাঁড়িয়ে
Nothing is recorded in the order.
Nothing.
No, my lord.
Nothing is recorded in the order. You paid for you paid for and allowed time for filing counter.
Yes.
This after 6 weeks. This
It was verbal.
verbal has no meaning to us because we are not present in that.
My lord.
Appears on caveat. Nothing of that sort.
But yesterday, my lord, they've paid us 5 lakhs.
Yes.
So the rest amount of another 15 lakhs, my lord, is due.
Yes,
At
is there any
the-
scope of agreement on anything?
They said 3 months. The
Yes.
only problem which I personally feel is that if he goes away, how much he's going to pay or honor is something which is in doubt, going by the conduct of the gentleman. Even during the settlement part, I was told by Mr. Chakraborty that he was very adamant. In a settlement, you can't.
We can take an undertaking from him, Mr. Chatterjee, specific undertaking during the course of the date we filed, one-page undertaking as to when he'll return next, his whereabouts, he'll be intimating
And what
to
property
his counsel. And we can ask the counsel to disclose to us at any point of time.
and what properties he has, let him-
Property
because
that
I am told, if your lordship call for his bank statement, the money
No.
is there.
My lord,
if
in
it
this
is put
regard, my
on,
lord,
if that will be execution. If he does not pay, then definitely you can ask for an attachment and we'll think about that.
my lord,
I have
Which
been
will be
taken
subject to the
instruction.
Supreme Court.
I have taken instruction.
Property will be here. Property will not go with him.
Definitely.
my lord, kindly in this regard, my lord, kindly Mr. Banerjee to come.
I have also taken instruction from my client. I have made her understand, 2 monthly installment, she is agreeable.
Very.
একটু বলতে দেবে না একটু আসুক
আমি আমারটা বলে দিই
ঠিক আছে।
এবার তুই বল।
এই তো
Mr. Banerjee will ask for an undertaking if your client is to leave the country today.
Yes,
Half page undertaking, just get it typed. We'll just tell you what regarding. He agrees to 2 monthly installments. And we may or may not record. If he wants, we can record that agreement. We may not also if he does not want. But we'll give you 2 months, not 3. 1. Secondly, that undertaking will contain when he will next return to India. 1. Secondly, that your client will be keeping you intimated about his whereabouts, and we can ask you to disclose that before court if occasion so arises. And obviously, the obvious undertaking that he will be paying those
Yes.
the
Current, my lord.
arrears in 2 monthly installments and current
Yes.
along with that.
Yes.
These are the 3 things. We'll put that in our order so that you can do that and leave the country for the time being.
Very well. My lord, I can only request my learned senior friend, my lord, for extension of my lord, this time, my lord, by 1 month more. I can only request my learned senior friend. My lord, I do not want to commit another default.
Mr. Chatterjee, the difficulty is yes. If he cannot pay, then I mean,
That's why I said ask for his bank account. The entire money is there. Yeah, and much
My
more.
lord, I need to sustain also. My lord,
Much,
it's
much
not
more.
That, my lord, that I need
or we
to-
can injunct you from I mean,
Injunction
not at
from
this stage, Mr. Chatterjee, not at
It's-
this
I
stage.
right.
Wait for some more time because the matter is
My lord,
pending before the
he can trust his my learned senior.
No, trusting on
judgments
Mr.
and stuff.
Banerjee won't do. We all
No,
trust.
I'm saying I can trust, but my client has a problem.
PDC থাকলে তো এমনি criminal
And
মামলাও
Mr.
হবে।
Banerjee is there, my lord, I can't trust at all.
Me, PDC, Mr. Banerjee won't. What is the meaning of a PDC?
Post-dated check, my lord.
Obviously, post-dated check. What's the meaning of post-dated
My
check?
lord, then my lord, he will invite a
Post-dated
criminal
check,
liability,
that
my lord,
will
a
be-
criminal prosecution
Why not
also.
a demand draft? Post-dated demand draft, I don't
Why?
know if it happens.
No, probably that is not.
I'll do that. A demand draft, which I will, my lord, encash after my 1 month.
My lord, I need to purchase the demand draft by my lord putting in the money. So
If he had
that
the
does-
money, he could pay.
That's
Then
what
the
my
installment
point-
would be meaningless.
That's what my point is. He has the money, he doesn't want to pay.
No. No.
We'll give him 3 months, Mr. Banerjee, but Mr. Chatterjee, but we'll put that in his undertaking.
Very.
A
And
copy,
also the, my lord, the current that he will pay along with
current,
those.
along with those 2 monthly installments you'll be paying, that will be the first undertaking.
Arbol.
Second undertaking, he'll put in that undertaking when he's next due to come to India, at least the approximate date. And he'll be keeping his counsel abreast
Whereabouts.
about his
My lord,
whereabouts.
advocate on record.
No, council.
Counsel.
Council.
You must take
Kindly do
responsibility.
not do this to me, my lord.
Council.
Enough has been done to you, so something else will not add much.
And
Yeah, আমি মরে যাবো তো।
and moreover, my lord, if he doesn't come, the council would be
The
responsible.
council will be, whatever order can be passed against his client can be passed
And
against.
he can
council.
always,
Lord,
my lord,
My
take
lord,
out
otherwise,
his-
my lord, otherwise also, my lord, I leave on my lord Rexipra, my lord serotonin overdose. My lord, kindly do not, my lord, increase that dose, my lord, for me.
How do you think we live, Mr. Banerjee?
my lord, the appeal also, if your lordship, my lord,
Appeal
permits,
dispose of?
hears it out.
How can we now?
After the vacation, keeps it.
After the vacation, you can direct it to appear in the monthly list of November.
Yes, yes.
We'll do that.
Yes. May I have my lord's kindly?
Yes. A copy of an order dated August 18, 2025, passed in special leave to appeal with bracket C number 12886 of 2025 is handed over to court by learned senior counsel appearing for the petitioner. Full stop. It transpires therefrom that the Honorable Supreme Court, by the said order, passed in connection with a challenge to the parent order regarding which this contempt has arisen, directed dispensed with formal service of notice in view of the appearance of the present petitioner, the caveator before the Honorable Supreme Court, and granted 3 weeks time for filing counter affidavit. The matter was directed to be listed after 6 weeks. Thus, we do not find anything recorded in the order to the effect that this court shall stay its hands in the contempt proceeding or any direction on the alleged contemner to pay any amount. Next para, be that as it may, fact remains that the parent order has not been stayed by the Honorable Supreme Court while admitting the SLP against the same. Next para, learned counsel appearing for the respondent alleged contemner submits that the alleged contemner is due to leave for abroad today, for which where is he going, Mr. Banerjee? Please take it. The specific place, please.
It's San Francisco.
Redwood City, San Francisco. Redwood City, San Francisco.
Redwood City is due to leave abroad, specifically for Redwood City, San Francisco.
491
San Francisco.
I'll give the specific postal address also.
Redwood City, San Francisco.
San Francisco.
San Francisco. Full stop. Next para. Learned counsel for the alleged contemner seeks 3 monthly installments for clearing of the entire dues of alimony by the alleged contemner. Full stop. The alleged contemner also undertakes through counsel to undertakes through counsel to pay the current alimony per month as per the parent order, subject of course to the outcome of the special leave petition filed against the same. Next para. Since the question of earning the livelihood of the alleged contemner is involved, as he is employed in Redwood City, we think we are of the opinion that it would be a disproportionate penalty at this stage if we restrain the alleged contemner from leaving the country, which would any event not inure to the benefit of the petitioner wife either, since unless the alleged contemner earns his income, it would not be possible for the alleged contemner to meet the arrears as well as to pay the current alimony. Full stop. Next para. As such, we permit the alleged contemner to leave the country for the time being and dispense with personal appearance of the alleged contemner before this court until further orders, subject to the alleged contemner filing an undertaking in writing in the form of an affidavit during the course of the day containing the following: niche Roman 1, the petitioner shall disclose the alleged contemner shall disclose his exact address in that exact address where for which place he is leaving India and where he would be residing and working during his period outside India. Full stop. Roman 2, the alleged contemner shall keep his learned advocate on record informed as to his whereabouts, with the clear understanding that in the event this court requires the learned advocate for the alleged contemner to disclose the current whereabouts of the alleged contemner, comma, the learned advocate on record for the alleged contemner should be able to do so at any point of time. Full stop 3, Roman 3, the alleged contemner shall clearly undertake that he will clear off the entire due arrears of alimony to the petitioner wife in terms of the order under contempt by 3 equal monthly installments, comma, the first of which shall be paid by September 10, 2025, and thereafter by the 10th day of each succeeding month, comma, directly crediting the same by online transfer to the bank account of the petitioner, comma, which shall be disclosed in writing by the petitioner through her learned advocate on record to the learned advocate on record for the alleged contemner by tomorrow. Full stop. Furthermore, comma, the alleged contemner shall undertake that apart from the installments of arrear alimony, comma, the alleged contemner shall also pay monthly alimony, the current monthly alimony in terms of the order under contempt every month to the petitioner wife by the same mode as indicated above. Full stop. Next para. Such undertaking shall be filed by the learned advocates for the alleged contemner tomorrow. Full stop. The matter shall be listed tomorrow under the same heading for such purpose and for passing further orders. Full stop. Next para. It is, comma, however, comma, made clear that all payments made in terms of the above undertaking shall be subject to the outcome of the special leave petition filed against the parent order by the alleged contemner before the Honorable Supreme Court.
Two things. I stay at Redwood. I work at Foster City. FOSTER. Foster City. And this is number 1.
যেখানে রোমান 1 বললাম ওখানটা কি বললাম একটু বলো তো আন্ডারটেকিং এ রোমান 1
এটা আমরা পাঠিয়েছিলাম এটি ওর অ্যাড্রেস তো
আমি আবার অ্যানেক্স করে দেব আন্ডারটেকিং এ অ্যানেক্স করে দেব
exact residential address and place of work, comma, for which he is living, for where he is living.
And I get salary on 15th of each month. So instead of 10th, maybe on 16th of every month from September.
ঠিক আছে যেটা 10 বললাম
Grateful.
first of which shall be by August 10 and thereafter by না করে first of which shall be by August 20 and thereafter by the 20th day of each succeeding month.
So grateful, dear Lord.
We are making some order which will be feasible, otherwise you won't get the payment.
I'm not objecting. No, this was our FRO service man make it kept on record.
কালকে টু বি মেনশন হিসেবে থাকবে অ্যাপেল সেল 10:30 বলছি না
Grateful.
আর ওনার পার্সোনাল অ্যাপিয়ারেন্স ডিসপেন্সিভ করে দিয়েছি কাজে কোনো অসুবিধা নেই টু বি মেনশনে থাকবে যখন অ্যাপেলের সাইড নেবো তখন ইয়েস
Grateful.
The appeal kindly be fixed. But the first appeal the date may be fixed as Mr. Chatterjee has.
Tomorrow we'll put it. Let him file the undertaking. We'll just remind us. We'll put it on. এটা লিস্টে হ্যাঁ লিস্টে ছাপা আছে
My lord, I am for the respondent,
My
madam.
lord, I am for the wife, my lord, the appellate. My lord, I have contacted my lord, my client. My lord, she desired to, if any possible, my lord, she will go to her husband's house. Though, my lord, previously there was an.
What have you challenged?
My lord, the order of, my lord, the judgment and order passed in favor of the, my lord, the husband, my lord, granting decree of divorce.
No, obviously you want to go back. That's why you have preferred the appeal.
My lord.
But he obviously doesn't want it at this stage. So let us try out mediation.
My lord, earlier occasion, they were sent for mediation. First date, both of them appeared. Second date, the wife didn't appear. And probably, my lord, there is an observation by the learned mediator, my lord. in the file.
এই পার্ট 1 এ মিডিয়েটরের রিপোর্ট আছে বলছে, দেখুন পার্ট 1 রেকর্ডস এর পার্ট 1 এ। Do you have a copy of the report?
No, my lord, last occasion when the matter was moved, my lord, your lordship has gone through the report, probably, my lord, so far I can recollect.
দেখুন তো মিডিয়েটরের রিপোর্ট একটা থাকবে। অন্যটা দেখুন, এটা তো ট্রায়াল কোর্ট রেকর্ড যে আমাদের পার্ট 1 এ দেখুন আর আর কোনো ইয়ে আছে কিনা, এটা তো সব এক্সিবিট গুলো রয়েছে, না লোয়ার কোর্টের অর্ডার শিট ফিট রয়েছে, মিডিয়েটর রিপোর্ট। অন্যটা দেখুন আছে পার্ট 1 বলে উপরে লেখা থাকে। On the last occasion, mediator sat with you. The next date was fixed. You did not come. Your client did not come. When advocate was contacted, he told that she is not interested to proceed any further. So if you say that you are interested, then we'll keep it. We'll give a last chance to the parties to mediate.
Will it give a last chance?
We'll give a last chance. Let us try once again, and if this fails, then obviously they will take up the matter.
Yes, I do. When the matter was moved, I moved the application for maintenance. But he's a railway
Mr. Bhattacharya, you try to impress upon your client so that she goes to the mediation at least.
So far maintenance
My
is
lord,
concerned,
maintenance have
I
been,
know, but so far maintenance is concerned, he's a railway employee. Railway employee. At a time, so 70,000 was paid, my lord.
Mediation will take care of maintenance, everything. And if it fails, you come back.
my lord, 70,000 have
That is
been
all
paid as per the direction
Start-
of this honorable.
70,000
Yes,
was
my
paid.
lord, I have the.
Only
papers
70,000,
for
it's a
that.
railway employee.
My lord, that
Take the
was-
microphone closer to Mr. Bhattacharya.
My
Only
lord,
70,000. This is the husband, maybe that was
my lord,
We are not
that-
arguing, we are not hearing the matter on merits.
a mediation.
And my lord,
Learned
here-
counsel for the appellant submits that the appellant wife is willing to go back to the respondent husband. Full stop. Such stand is rather obvious, since the present appeal has been preferred by the appellant wife against a decree of divorce obtained by the husband, respondent husband. Full stop. Learned counsel for the appellant seeks to raise an issue as to the payment of alimony being meager, whereas learned counsel for the respondent husband submits that an amount of rupees 70,000 was paid by way of alimony in terms of the direction of this court. Next para, be that as it may, we find from the final report of the mediation authored by a mediator on an earlier occasion when the matter was sent for mediation, that although the parties attended mediation on the first date, on the second date fixed, the appellant wife neither appeared before the mediator nor expressed that she was not interested in participating in the said process. Subsequently, her lawyer was contacted who indicated that she was not interested to proceed any further with the mediation. However, since the wife now seeks a second chance at mediation, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of exploring the option of mediation to resolve the dispute between the parties either way. Full stop. it is made clear that it will be open to the parties to touch upon all issues which are causing friction between the parties before the mediators. All issues include maintenance and mediation. As you know, Mr. Bhattacharya, it can go either way. That's why you have put in either way. Either you part ways or you go back. Both options are open. Next.
I am for the petitioner.
Petitioner, yes.
Yes,
I am for the applicant, the can one.
Addition of party.
Yes, my lord.
My lord, may I may I get the privilege of filing an affidavit in opposition to the
Addition of party?
yes,
What is the
because the
nature of
post-vesting transfer is praying for addition of party in a proceeding. The proceeding has been initiated by the sons and successors, heirs of the intermediary. So first the intermediary will have to adjudicate whether their land is liable to be vested or not. In that proceeding, this post-vesting transfer is there willing to be added as a party. So post-vesting transfer as on date until the vesting issue is being finalized between the intermediaries and the state under State Acquisition Act. I want to file opposition. Kindly give me 3 weeks, Lordship.
My lord, I have no objection in filing opposition. Only one thing, my lord, I am pointed out before your lordship. My lord, your lordship kindly come to page 35 of my application. My lord, the last occasion, this honorable court directed the BLRO Sutata 1 to take the matter along with these patta holders and these petitioner. Regarding this, my lord, what happens? My lord, we have purchased the property from the predecessor of the present appellant before your lordship. And now what happens against that, my lord, in 2003 onwards, some pattas has been given in respect of the land, which has been directed to be retained by the then BLR. Against that self-same BLR's order, another BLR when came, my lord, he challenged that order before the appellator. There is the dispute. Because we have purchased the land from the retained land of the such and such person. That's why, my lord, when we are harvesting the land, these patta holders came and, my lord, everything has
been. Petitioners, do you want to use any opposition? What is your stand on the?
No. It is not.
Obviously not.
They are the heirs of the intermediary. From
very well. Learned counsel for the respondent
state lordship.
State seeks an opportunity to file an affidavit in opposition to Can 5 of 2025, which is an application for addition of party. Full stop. Next para. The you are appearing for respondent numbers 1, 2, 3.
Lordship. Let me
accordingly, the respondent numbers 1 to 3 are directed to file their affidavit in opposition to the application within 3 weeks from date. Full stop. Reply finish shall be filed within a week thereafter. The application shall be listed for hearing on September 23, 2025. 2025.
My lord, one submission of your lordship. Earlier the order was passed, your lordship kindly go through it. What happened? It is 6/7/2007.
6/7/2000?
2007.
2007?
The order passed by this.
Pending since 2007?
Yes, my lord.
Yes, P34 is of WPLT is of 2007.
2007.
I think there was an order that permitting the appellate authority to proceed with that.
Mr. Khalid, can you file your opposition within 2 weeks?
It is
that is the
may I submit one thing? It can be disposed of immediately. Nothing has been no purpose to keep the matter pending before this court. What happened?
Then we won't add them. If they don't proceed, then we can take it up right now.
No, he is addition of parties. But main, my lord, the petition which was filed by me, I am the intermediate.
Can it be taken up if an interlocutory application is pending?
No, my lord, it is
what is the law on that?
Your lordship kindly fix a date.
One minute. That is, my lord, land schedule has been given in terms of the, my lord, section 6(1). He challenged this order.
See, there's no use wasting time. Either we take up the writ petition, he not presses his application because you are selling on the
yes.
or he presses his application and then we'll have to give them opposition. Yes, can you do it within a fortnight?
Kindly make it 2 weeks.
Thank you very much. 3 weeks টা 2 weeks করে দিন। আর তারপর
Weeks,
1
1 week.
affidavit in opposition within 2 weeks from date. Reply if any within 1 week thereafter. The application shall next be listed on September 10, 2025.
Lordship.
The understanding is we'll take up this addition of party application immediately thereafter. We can take up the main matter.
Yes,
also.
ma'am.
On the
If it's
same
a short matter.
Same day, my lord, the hearing to
If
be
it's a
made.
short matter.
Short, very short.
Very
matter.
short matter.
Very short matter. 2 or 3 minutes. 2 or 3 minutes.
If you dismiss your application, then you can assist your learned friend in arguing.
Yes, yes.
You can always do that. No difficulty in advocates assisting
Mane-
other advocates. So you'll have your fill also.
Very petty
That's
case.
just a guy
2
who
or
take
3
instruction
minutes.
what time. If your lordship
To
kindly fix the
maximum
matter,
5 minutes is required to, my lord, the
But
district
your
office.
Minutes are already gone. How do you say 5 minutes will be gone?
my lord, if your lordship kindly fix the matter tomorrow, then my lord, I can take my instruction and my lord, your lordship kindly.
No, then you have to waive your application. It's a
That's why, my lord, I am praying. If your lordship kindly takes the matter tomorrow, then my lord, I have contacted with my client and says that this is.
You'll
the
not
date-
press this application and we'll
Yes,
take up the main.
regarding this. But this order may be passed tomorrow, my lord. I can say that. If your lordship kindly thinks.
Tomorrow I will meet Baba, next week করতে হবে।
Abar next week করবো।
না, tomorrow আমি থাকবো না।
Let it be as it is. Mr. We are making it clear. If you feel that you don't want to press the application, you can come back and mention it day after tomorrow and we'll keep them in repetition. We'll put it as to be mentioned and we'll take up the matter. But the direction remains. You prepare your affidavit in opposition. Now exchanged, breakup.
Yes, my lord, but we have agreed.
You have agreed, thank God.
Because
Two levels of breakup. One is breakup of the arrears and one is breakup between the parties. You are enjoying a divorce decree or your
Yes.
divorce decree, you are challenging that.
Yes.
Achha.
Madam, in this application, may I permitted to submit something, madam?
Please use the microphone, Ms. Banerjee.
My lord, the husband,
What is this application for?
this application is for area of payment, madam.
Implementation of. Let us look at the application. Can 6.
my lord,
Payment of alimony and for payment of arrear amount.
Lord, when we file one application, Lord, can 4, Lord, at that point of time, they filed one application for modification. Modification of the order, original order that was passed on in the April on.
What happened to that modification?
That modification has been rejected. And the order of 10,000 has been confirmed, for which we have again come back before your lordship, because your lordship has in the meantime directed them to pay 7,000 as ad hoc in the meantime, from February to
So
July.
that 3,000 balance has not been paid.
3,000 balance. has
Current
not
they are
been-
paying.
Yes, Lord.
Current you are paying. So
7,000.
this 3,000 arrears will be on the 3,000 component.
3,000 component for the 3 month.
What is the amount due?
Now, my lord, total amount due becomes 2,10,000. But we have missed two payments, Lord, which they have paid.
So what is
from
the total amount agreed amount?
1 lakh, 1 lakh.
180.
80,000.
Acha, what do you do, pensioner?
Nothing,
No.
madam.
He's
Nothing, no husband does anything after
No,
matrimony.
Private.
Once getting the divorce,
private
how do you, what is your livelihood?
Like I'm depending upon my pension of my father.
Why did you marry?
Lord, he's an engineer from BE College, Sipur.
Shouldn't have married then. If she was with you, you had to pay for her. That is the standard that on which we grant alimony. If she was with you, what would you have to bear for her?
He's a child. Lord.
10,000 per month. There's a child. Child is adult now.
Yes, yes.
He's now studying in class 11, Lord.
Boy or girl?
Boy.
11, what is his age?
He has just reached 18.
18 years.
Difficulty is, although 18-year-old boy does not have a means to earn, but anyway. So,
My only prayer is
10,000 is nothing. We should have enhanced it.
my lord, it's unbearable for my client to pay the amount itself.
Then he has to go to jail, Ms. Banerjee. Nothing doing. 10,000 is nothing in today's world. 10,000 is nothing. You said private tuition. On what subject? And which class? I'll give you the breakup. Give us the class of the student. How many students he is teaching and what subject? We'll ascertain and we'll tell you the breakup.
that information, my lord, with me right now. But my lord,
No,
my
we'll,
only prayer is
you are already at the risk of going to jail, ma'am. No, no question of that. So 1,80,000, pay it by 2 monthly installments.
at least 6 months time.
You break up your whatever your fixed deposits and all, you pay her. No.
My lord, kindly give 6 months time to pay
6
the
months is
area.
out of question. You have not paid. Why should you rely on your client? Yes, Mr. Mukherjee, what is the reasonable time we should give to him?
I'm leaving into your lordship, Lord.
Leaving it to us would go to their benefit. We are very lenient on this.
Lord, make it 3 months, Lord.
Do you have any information what he's doing? Anything else?
Lord, he is employed in a private concern, Lord, and he is the engineer, Lord, from BE college.
Engineer from BE college may not have a job also. We don't know. Then he must be teaching physics and maths.
But
Which
my
gets him
information,
quite
we have
a
stated,
quite a
Lord,
good
that-
income. We can assure you if he does that. If an engineer from BE college is sitting, he must be teaching physics and maths. And if he imparts private tuition and he's earning something from that, you can pay up 3 months, three installments.
Kindly make it 6 installment, my lord.
We are very bad at negotiating. We make it 3.
Well, can you make it something so that he can pay, my lord?
3.
It will be difficult for
1,000
to
per
pay
month.
because there is a continuation of payment is there for 10,000 per month.
10,000 obviously plus
Current
this.
payment. So it will be difficult. Again, my landed fed has to come before your lordship.
তারে কত হিসেব করতে অসুবিধা হচ্ছে 1,80,000 4 দিয়ে কত
45,000, Lord.
Make it 6 installment, my lord.
No, my learned brother says 4. I agree to 4.
There is one more prayer, my lord. If your lordship can fix the appeal is otherwise ready for hearing, my lord.
After 4 months, clear of the alimony first. Principle of suit.
Make it 6 installments because it's very it's unbearable for him to pay. Right now, his father is in ICU. So there is a
You're
medical.
condemning 6. If you can't pay again, you will have to come up and you will have to spend money for
As
this
your
application.
lordship pleases.
You are getting the 10,000 and this will give.
As your lordship pleases.
The present application bearing CAN 6 of 2025 has been filed for implementation of an order of alimony passed in connection with the present appeal, whereby the respondent husband was directed to pay an amount of rupees 10,000 per month. Full stop. It is submitted by learned counsel, learned senior counsel for the petitioner, appellant stroke petitioner, stroke wife, that as per direction of the court, the respondent husband is going on paying the current alimony of rupees 10,000 per month. Full stop. The respondent also paid rupees 7,000 per month for a substantial period, thus leaving rupees 3,000 per month for the said period as arrears, calculated at the rate of rupees 10,000 as directed by this court. For sub next para, learned counsel for the parties have sat together and have agreed upon the arrears due, which comes to rupees 1,80,000. For sub next para, learned counsel for the respondent husband submits that the respondent husband is without a proper job and is earning his livelihood by imparting private tuitions. Full stop. Learned senior counsel appearing for the appellant opposes such submission and argues that the respondent is a qualified engineer from the BE college, Shibpur, and is engaged with a private concern. Full stop. Next para. Since none of the parties produce any document in support of the respective contentions, as per the law, a reasonable guesswork is permitted. Full stop. Hence, we grant the payer of the respondent to clear off the arrears of rupees 1,80,000 per month, 1,80,000 by 6 equal monthly installments. Full stop. Accordingly, CAN 6 of 2025 is disposed of by directing the respondent husband to go on paying alimony, current alimony at the rate of rupees 10,000 per month as per the previous direction of this court. Full stop. Over and above the said current alimony, the respondent husband shall pay the arrears of alimony to the tune of rupees 1,80,000 by 6 equal monthly installments, comma, payable by the 15th day of each month, comma, the first of which installments shall be paid by September 15, 2025, and thereafter by the 15th day of each succeeding month till such arrears are cleared off. Full stop. Next para, no orders to cost.
I'm great.
My lord, appeal is otherwise ready.
Learned counsel for the respondent husband submits that the appeal is otherwise ready for hearing and may be fixed for hearing. Full stop. Next para. However, comma, it is a well settled principle of law that in cases where there is an arrear of alimony, comma, the court shall not take up the main suit stroke appeal for hearing unless the entire dues of arrear alimony are cleared off by the defaulting spouse. Full stop. Accordingly, we desist from passing any direction for the appeal to be heard out prior to the entire dues of arrear alimony being cleared off by the respondent.
Great.
I am opposing this. I am for the respondent cross objector.
Yes, well, this is the interesting point. Well, which I am eager to
Argue.
argue.
Review how far we can go into that is the
Yes,
difficulty.
yes, well, yes.
Otherwise, many of your matters are undoubtedly interesting. The points involved are interesting. But
Yes,
review
my
the
lord.
scope
Here, my lord, I am going into the root of the case. My lord, here, first appeal preferred by the state, challenging the reference court order. So, my lord, and they filed a cross objection. And my lord heard those matters analogously and come.
You filed a cross objection.
No, the other side.
The respondent.
Yes. Oh, you are the
Yes,
you are the landowner. Yes, land loser rather. Very well.
yes.
You are for the state, right?
Yes. So, my lord, the first appeal dismissed, their cross objection allowed on the ground, primarily on the ground, that the award dated such and such it is to be treated as a void one.
Yes.
Since it has the limit, prescribed limit, that is statutory period of 2 years. Within that period, no award was passed. That's why it is a void one. So, my lord, my first point, my lord, that after all, this is an appellate court. My lord knows that reference, this is an appeal. And my lord, my first point, I am arguing subject to my lord's kind approval because I have got the best bench. So for the civil matter is
depending on the outcome.
No. Because this is my perception, and everybody will accept that, my lord. I am not praising myself. I have got no audacity to
you say that you are gone.
Yes, I have got no audacity.
We are already prejudiced against you.
No, my lord, I am not. I am not a person like that.
But what is the point?
Point is,
we get the point, the other point, but what is your legal point?
This is the legal point, my lord. Kindly consider first the admitted fact.
Yes.
The acquisition was done under the Act 2, that is 1948 Act. And my lord, there, Section 3.1, my lord, that is requisition. Section 4.1, that is like 17.1 of the Land Acquisition Act 1894, Act 1. That also repeat. Now, my lord, the Section 4.1, once it is invoked, even if no decree were be passed, my lord, that proceeding cannot be treated as a lapse one. Because in Section 4, it is inbuilt in the provision that before, my lord, that once Section 4.1a, one is 3.1 requisition of Act 2, my lord, 1948 Act, and one is Section 1.4.1 was being invoked at that material point of time, then land was vested to the state. However, even if no compensation be paid, even if no award be passed. And yes, award to be passed, but under which provisions of law? That is the question.
There cannot be any question of the lapsing.
lapsing. There
Because the
cannot be-
land you say automatically vests with
vested,
the
yes.
with the
And there is
acquisition.
no provisions in the IF law that after vesting, because in the section 4(1)(a), it is clear land is vested free from all encumbrance. That is a clear provisions in that. Well, now my humble submission it would be that yes, no award, no compensation, that cannot be the logic. And my lord, I argued before the Honorable Division Bench of our Honorable High Court. In the same question issues were being involved, that yes, under which act the award will be given. The Honorable Division Bench held yes,
Current.
that
I mean,
the
1894.
1894 Act, it would be applicable. And at that point of time, that the recent judgment of the Honorable Lapis, 3-man bench judgment, after the, my lord, the 5-man bench judgment, that is, my lord, in the development, my lord knows that. My lord, 3-man bench judgment, there the question arose, if Section 4 was issued, because I have a case, another case, my lord, that will come on later on, because here it is also being involved, even in Section 4(1) of Act 1, my lord, I am saying Act 1, was invoked, then whether the authority, even if the act lapse or in terms of law, the 1894 Act, Act 1,
Time limit.
repealed,
Yes.
then it will not be actually there, the government is not, my lord, any restriction or no restriction was imposed regarding that they have to proceed in terms of the provisions incorporated in 2013 Act. That is the new Act. So, my lord, proceed in accordance with law, even if it was invoked prior, after, my lord, suppose after January 2024, that is the new Act has come into effect. Even in that scenario, Supreme Court 3-man bench held that once Section 4(1) was issued, it will be, there is no bar for the authority to proceed with the subsequent 6, 9, 11. And my lord, ultimately, the the Supreme Court held that the only provisions, that only compensation part, that will be governed so far the compensation part is concerned, so far the award is concerned. That is the judgment. And before that, my lord, I am placing, my lord, one, my lord. First of all, my lord, even this one point. Second point I am canvassing, my lord, I need not trouble to go, my lord, because, my lord, order 41, rule 22. My lord, the cross object. But I am taking this point because in the reference, this original, I could have understood that in the original revision, the reference case, because application has to be filed before the district court, district magistrate, and it will be automatically, it would be referred to the district judge, where there is the acquisition judge, learned judge of the lower court. So, well, I could have understood the point was taken in that award is a void one. Then the question would be otherwise, because if in first appeal, this is almost, my lord, this is first appeal, my lord, no new point can be urged because of, my lord, the first of all, the section, order 41, rule 22 explanation. I am reading, my lord. Cause objection, my lord knows that, just relevant part I am reading. A respondent agreed by a finding of the court in the judgment on which the decree appealed against is based may, under this rule, file cross objection. In respect of the decree, so far it is based on that finding. Notwithstanding that, by reason of the decision of the court on any other finding, which is sufficient for the decision of the suit, decree is wholly or in part in favor of the respondent. Now, coming to the question. Well, I could have understood that point was raised, even not raised, discussed, evidence was taken. Then question, my lord, can take up this issue. But my lord, where is the case? Nothing. There is nothing. Only they are agreed with the lawyer announcement because they are they want that great enhancement to be done. That's why they were agreed, and that's why, my lord, they can file a cross objection saying that this amount will not do. I want further amount, because I have also filed an appeal.
regarding enhancement is bad. They could have come up by filing a cross objection, because based on that finding, there is nothing in the judgment, impugned judgment, that no discussion regarding that plea. So my lord can stick, my lord cannot go into that question, because recently, my lord, I have come across, this is also in a suit, because arising of suit, my lord. This is the latest judgment, reportable. Well, I am handing over. My lord, here, this is the latest judgment. My lord, it was এটা হচ্ছে 8th August 2025. এটা হচ্ছে স্পেশাল লিভ পিরিয়ড সিভিল অ্যাপিল নাম্বার 22070 of 22070 of 2025. My lord, here, my lord, the case was, sorry, এটা না আমি জানি. My lord, kindly come to page 7 of that judgment. My lord, here, first appellate court, my lord, taken the point, only in the plain, there was no pleading for adverse position. First appellate court point was taken, discussed and dismissed. In the second appeal, no, you cannot do that, because it is hit by order 20. My lord, order 41, rule 22, explanation. My lord, you cannot do that, because there was no evidence, there was no discussion, there was no pleading. You cannot treat this in your first appeal. And second appeal restored the trial court order. And challenge your appeal court, because the whatever judgment was passed in the second appeal, that was there. So, my lord, this is the case. My lord, here, my lord, I am citing this decision for this case. And my lord, another judgment, my lord, that the my lord, he knows, because I have only one copy. My lord, kindly see this, my lord. I am only, my lord, I am handicapped, because only seeing, my lord, এটা হচ্ছে MAT 1545 of 2018, State of West Bengal and others versus Sri Shaktipada Saha Chaudhary and others. 1545 of 2018, State of West Bengal and others versus Sri Shaktipada Saha Chaudhary and others. 12/4/2022. Well, kindly see only one. I am sorry, my lord. I am extremely sorry. So for them, my lord, this is the order regarding that once 41A was issued. Right, apart from this point.
Is that not a very big judgment?
No, there is not a big judgment.
You can take out you could have taken up 2 copies.
Yes, I will, because certainly, my lord, I have, my lord, and my lord, regarding
this Justice Sanjeev Khanna and Justice Najir, this one?
No, that is our honorable division.
Acha, MAT.
Only point discussed.
Prepaid judgment. Give us a copy. Give us.
Yes, I will.
What is the proposition
But
here?
proposition that once 41A was invoked, yes, compensation will be paid in terms of the provision of Act 1, not under Act 2013.
But in this particular case, there's an order by the division bench probably that compensation would be paid under the new nothing.
No. Well, this is absolutely, it has come from the reference court. My lord was, yes, it is, my lord, it is appeal, my lord, state.
No, in your case, in the case we are hearing now.
That is in respect of the reference case.
No, wasn't there a direction of the High Court at some point of time that the compensation applicable?
No.
We are confusing
No. That is not. That is, my lord. My lord was thinking, my lord, that is in another case when Mr. Joint. Yes, Mr. Joint with the appeal. That's why, my lord, and my lord, there is. And my lord, before that, my lord, there are another honorable division.
Just give us 2 copies of this.
Yes.
Just take a note.
And my lord, another thing, my lord, kindly see regarding that enhancement. Our appeal, that enhancement is not in accordance with law. For which I have prepared, I mean, state has prepared an appeal. The appeal was dismissed. My lord, against that, my lord, this I am referring. Regarding, this is the latest judgment so far, how the compensation can be assessed in a reference court. Well, this is the latest judgment.
But in review, can we go into these legal arguments?
No,
These are good
because-
grounds for appeal.
No, my lord, review, yes. Review,
These are unreported judgments, Mr. Shenugupta. You should have
Reported.
supplied copies to you.
yes, I will supply, I will hand over this.
You're giving one copy. How can we?
No, no,
how are we? You have given a copy to him also.
No, I am.
Have to give it. These are unreported judgments. How can they follow?
This is latest judgment. I am.
Latest judgments have to be given. Copies have to be given.
Yes, I will give. I will hand over the copy. But my lord, kindly consider one thing: the review. My lord, kindly consider.
Review. How far we can go? These are
Yes,
legal arguments.
no, review
You are
because
the state. Go before the Supreme Court and argue.
no, I cannot. My lord has got enough power in the review.
Review.
Yes,
Legal arguments. Purely legal arguments.
my lord, kindly see. This is the judgment I am placing. After
This also we must be having two copies only.
first, there are two points, the legal points, my lord. I have looked. Initially, it was against me. আরে দিচ্ছি দাঁড়ান জজ সাহেবকে আগে বললাম তোমাকে সব দেবো আরে তুমি সব জানো
You'll never get it.
no my lord.
You'll never get it.
My lord, kindly consider one thing. This is the pioneer judgment of this. So far, no section 5 is required. So far, the review is concerned. And my lord,
So no section have you required?
in review. Yes, my lord, this is the my lord, based on my lord, the Honorable Division Bench, the Honorable Justice Bhattacharya. And my lord, initially the Honorable Division Bench actually I was rebuked like anything, 3 days. They didn't accept my proposition of law. After that, even I lost in the Supreme Court, state. Even in that scenario, I pointed out because these are records. My lord, kindly consider. If the record says, if the records and the patent error, my lord, it was not taken into account. If it is not taken into account by the Honorable Division Bench as well as the my lord Honorable Apex Court, and Honorable Apex Court judgment is the simply SLP dismissal, my lord knows that the judgment that it cannot be treated as an affirmation of the Honorable Division Bench order. So, my lord, at that junction, my lord, I have cited all those judgments, and it was, my lord, held the Honorable Division Bench based on, my lord, because I was searching at that point of, because I know I have read that judgment of the Honorable Division Bench, and after searching, I got it. And as soon as I hand over this copy, then the Honorable Division Bench, yes, Mr. Shenugupta, you are right. And my lord, if there is a my lord, kindly consider. First of all, if there is, my lord, there patent illegality or sufficient reasons to interfere. My lord, sufficient reasons is to be analogous to that patent illegality. If suppose, my lord, in the act, suppose somebody, but there is a law, it was not pointed out. Supreme Court says yes, if it is not pointed, if it was there earlier, not after, then review is applicable.
Monohar, Justice Gawai's judgment for what point?
But that is for how the assessment regarding compensation can be done by the LA collector as well as reference court, or in considering all those Supreme Court judgments.
How is this relevant for your case?
Because in the FA, because my lord, because I have lost, my lord, because my appeal didn't succeed, their cross objection were allowed.
So what was the wrong in that? I mean, what is different from this?
No, because if the appeal be heard, that's why I will.
The chest is speaking more than your mouth in the microphone.
This is not recorded. My lord knows that. My lord, only thing, my lord, so far this point is, I think, my lord, subject to my lord's approval. My lord, kindly take up and decide the case. Because nothing will, because my lord, they are not, they are not gaining anything, because everything, because suppose the reference was set aside, then my lord, they will get nothing. Again, what the 2013 Act, it will take 2 years, 3 years, but decide this point. Obligement. This is the case.
Yes.
This is the first hurdle I have to overcome. Then, my lord, I think, my lord, I am before the.
Mr. Shenu, please just give
yes,
us
I will.
copies of this.
Hey.
Two photocopies of this and photocopies of each to Mr. Bera.
Yes.
Each of the judgments, photocopies just hand over so that he can come back and argue on this.
আপনি সব জেনে শুনে
Take out 2 photocopies for us, Mr. Sengupta. You have argued. Give him
Yes,
copies.
hand over all those.
Let Mr. Bera come back tomorrow or day after, whenever you want to come, and we'll hear you on this.
My lord, kindly for the time being, my lord, pass an order so that, my lord, I think, my lord, this point, my lord, kindly, what I am on.
What order now?
I have subject to my lord's approval.
We can only say, we can
kindly-
say that these are legal
kindly-
points, not amenable to review.
This is a
That we can say, that is the only short order we can pass. The shortest order in a
Yes,
review
yes, yes,
application,
short.
shortest order is that
Yes, yes.
these are amenable to challenge in an appeal because these are legal points. So review is not maintainable. If you want us to pass that, we can
No, no,
pass
no,
it.
no, my lord,
Otherwise, you have to hear Mr. Bera also on this.
No, my lord, because I think, my lord, there is a point for that.
Third, learned counsel for the review applicant, full stop. Learned counsel is requested to circulate copies of the judgment cited by him to the court as well as to the learned advocate for the respondents in the review application during the course of the day. Full stop. Let the matter be listed on August 25, Monday. August 25, 2025, under the same heading for further hearing.
My lord, only one point. Review of the judgment, nothing has been shown.
Acha, it is made clear that the question of maintainability of the review application is kept open for being argued on the returnable date. So we'll hear lock, stock, barrel. Maintainability as well as if you find it to be
My
maintainable.
lord,
you
I
can
want a judgment from my lord. Either way. My lord, I am not on that. But my lord, I think, my lord, subject to my lord's approval, there is a point. Because review, my lord, if there is something, my lord, is contrary to law, yes. Because
Shall
law
we, if it's apparent on the face of record, we have to
apparent, yes.
have to consider.
Yes.
Hey, take to
There is no
note.
there is
Aman, note.
and there is no requirement for evidence, taking evidence.
Yes,
Simply, yes.
On the
it
face of
appears
the
on the face of. My lord, instead of Monday, we have no.
Tell us, give us a date. 25th.
That is Mongolbar বাজে day, বুধবার।
No, this is Monday. 25th is Monday.
Monday.
Monday, my lord, সোম মঙ্গল হচ্ছে না,
No,
মঙ্গলে
Monday,
উঠা, বুধে পা।
Monday.
বুধে পা, my lord, বুধবার।
We keep your power on booth, but we'll hear it on Monday.
Yes.
Monday.
You have long legs, so no difficulty.
Yes.
Six is same. But possibly this is court, nothing. Six auditor. Six was same possibility number possible.
6 is same.
Yes, 6, my lord, because
Six
two
is-
appeal. In my
5, 6 is the common order.
yes, common order. Because two appeal, one cross objection and against
Right. Seven.
না আমার কপিগুলো কোথায় গেল? এই কপিগুলো
আর কপিগুলো কবের মধ্যে দেবেন তার
By today, we have directed them to give by today.
yes, yes.
Court's copies দুটো অর্ডার উনি দেবেন। উনি দিতে উনি দুটো কপি আমাদের দেবেন জাজমেন্ট। আমাকে ওদের যা দেবেন। Yes, 7, who is appearing?
I am for the appeal, madam. This is an application for restoration, madam. The appeal has been dismissed for default on 7/18/2025. But we have filed within time, my lord. And my lord, we have stated the grounds at page paragraph number 2, my lord. Paragraph number 2, we have
Filed within time. Paragraph 2.
within time.
Yes, what do you say? Seriously opposed. This relates to our determination otherwise.
This group one appeal, madam, mandamus appeal.
Well, we'll allow the restoration application. Is there any application pending?
Well, we have prepared the stay application, but we could not file because prior to that, the matter has been dismissed for default.
So restoring it since there is no state. Hard learned counsel for the parties, full stop, in view of sufficient explanation for the absence of the appellant on the relevant date having been made out in the application, comma, can 1 of 2025 is allowed, thereby recalling the order dated July 7, 2025, whereby FMA 1080 of 2025 was dismissed for default, and restoring the said appeal to its original file and number. There will be no orders to cost.
Great. 8, my lord, I am for the appellant.
Yes.
My lord, this is my affidavit of service.
Acha, respondent's number 4's address does not tally with respondent number 4 of the impugned order. What about that? Your memorandum respondent number 4 does not tally with. What is the difference? Let us check up.
project director.
Exponent
project
number
unit.
4 here is project director, project unit.
number 4 should be
সবই তো এক আছে। Exactly same.
Same.
Oh, there was a leave given to correct. You have corrected.
Acha.
That was the initial defect. You have corrected. Now the defect is removed. Sorry. Yes. You are for the other side?
Yes.
Right.
State.
State. Yes. Union, not state.
No, state.
Oh, there is union as well as state.
Union
You
as
have
well as
stopped on the
state.
union also.
Yes, yes, yes.
What is the matter?
My lord,
State is supporting you.
no, obviously not, my lord. And
If
my
the
lord,
union
they
is opposing you, state must be supporting you.
are- usually
Enemy is enemy concept. What is the matter about?
my lord, this is in short, my lord, this is a my lord, interest on the my lord, delayed payment. My lord, let me
Payment as in by way of compensation.
yes.
Your land was acquired by the national highway. Yes.
My lord, let me place the facts. My lord, my land was acquired.
So your limited context of the appeal is interest.
Only interest part, nothing more, nothing less.
You can take your seat. We'll just hear him and then.
My lord, my land was acquired. Compensation was awarded. My lord, within time. My lord, this was not being disbursed. For that reason, my lord, I have approached this honorable court.
Right.
My lord, that is relevant because that is upon which my lord, they are relying on. My lord, your lordship would kindly come to page number 43. This is the order. Your lordship is taking up the can.
Yes. 43 is the
43.
order impugned in this appeal.
No. This is an earlier
order. Right.
earlier read.
Yes.
Well, this order has been passed that it has to be disbursed within 16 weeks.
From communication.
Disposed of. Then.
Right.
My lord, finally the amount was deposited on 28th June 2021. That is at page number 45. My lord, I am not disputing that.
28th June.
June 2021. Compensation was awarded, which had to be paid within 27th February 2019. And amount was deposited on 28th June 2021. So, my lord, there was a delay of 2 years, 5 months, 13 days in making the payment. My lord, I made a representation.
2 years, 5 months, 13 days from
the date of payment. Well, from the date of compensation, well, which was awarded 27th February 2019. These dates are undisputed. Your lordship would kindly come to page number 46.
yes.
My lord, the gist is that আমার ক্ষতিপূরণের নির্ধারিত অর্থ আমি 2 বছর 5 মাস 13 দিন পরে পাই। প্রকাশ থাকে ওই সম্পত্তি দাগের উপর মধুচন্দ্র দত্ত সোয়েনসো মামলা করিয়েছিলেন, কিন্তু তাতে টাকা প্রদান না করিয়ে স্থিতাবস্থার আদেশ ছিল না। তথাপি সরকার ইচ্ছাকৃতভাবে আমার টাকা আটকে রাখেন। তখন আমি আমার অর্থ পাওয়ার জন্য মহামান্য উচ্চ আদালতে মামলা দায়ের করি এবং তাহার পর আমার নির্ধারিত মূল্য পাই। আমি চাষের উপর নির্ভরশীল, তাই জমি অধিগ্রহণের পর বাজার থেকে চড়া সুদে টাকা ধার করে পরবর্তীকালে টাকা শোধ করি। আমার বিনীত প্রার্থনা এই যে অবিলম্বে বার্ষিক 18% হারে সুদ 2 বছর 5 মাস 13 দিনে প্রদান করিয়া বাধিত করিবেন। This was on 23rd August 2021. Now, this was a big plot of land. My relatives had share in those plots, in those plots as well. One of the co-sharer, I'll say, Rajesh Dotto, he made a representation. Incidentally, I, advocate, I filed that application of Rajesh Dotto. My lord, Rajesh Dotto's order, your lordship would see page number 47.
That included interest at the rate of 10%.
Yes. My lord, what has happened?
For the
my lord,
same plot, another co-sharer.
My lord, this 47 has to be read in the light of page number 41 as well. This will be also their contention. 41, what has happened? My lord, the writ petition kept pending. My lord, there was a direction passed by the my lord Justice Ashish Kumar Chakraborty that this compensation has to be disbursed. Page number 41.
But you did not ask for interest then.
My lord, in page number 41.
41 or 46 or anywhere. 43.
Page number 41 regarding Rajesh Datta.
Oh, that was Rajesh.
Rajesh Datta.
Before Justice Ashish Chakraborty.
Ashish Chakraborty. My lord.
No, before Justice Vishwajit Basu. What was your prayer? Just to disburse the compensation.
No,
that was the only.
No. My lord, there was a prayer for my lord, disbursing of this interest as well.
Then it is a deemed refusal of that.
My lord, regarding that, my lord, this is precisely their point. My lord, I'll show your lordship. I'll show your lordship. My lord, your lordship has seen page number 41.
Rajesh Datta is a different case, but you didn't ask for this.
My lord,
we get you. You ought to be parity. There ought to be parity between two. But that stage has been crossed.
Not only on the point of parity. My lord, I'll demonstrate. My lord, kindly bear with me. My lord, don't take me amiss, my lord.
Why?
Why
amiss? Because you're arguing for your client.
No.
Courts start taking people amiss for arguing for their clients. Court should not exist.
My lord,
yes.
Page number 41, my lord. So there was a direction passed upon the respondent number 8 in the original writ petition that this has to be disbursed. Writ petition was pending, and finally Rajesh Datta's order at page number 47, my lord, the interest was at the 10% from so and so period. That delay period. This order, Rajesh Datta's order, was challenged before a division bench. That is at page number 49. Relevant portion would be at page number 53.
Yes.
The learned single judge, while passing the order dated so and so in WPA number so and so, directed the special land acquisition officer Paschim Medinipur to pay the compensation amount within so and so date. The writ petition was kept pending. Thereafter, the same was again taken up for hearing on so and so, when the learned single judge, after taking note of the fact that the compensation amount has been paid on so and so date, decided the issue regarding the payment of interest for delayed payment of compensation. The writ petitioner claimed interest, and there was no waiver on the part of the writ petitioner to claim such interest at any point of time, as sought to be argued by Mr. Datta. Mere pendency of the civil proceeding cannot be a ground to avoid payment of interest on compensation amount for delayed payment of the same. The learned single judge assigned reason for holding that the concerned authority was liable to pay interest on the compensation amount. The learned single judge was thus perfectly justified in directing the appellant to pay interest on the compensation amount, and the order rejecting the review application also does not suffer from any infirmity, as there was no error apparent on the face of the record, as rightly observed by the learned single judge while rejecting the application for review. Honorable Supreme Court of India, in case of Pramod Gupta, held that where the right to claim interest has been expressly waived by the parties, and or their counsel, our discretion is vested with the court, and the court may not exercise discretion to grant any interest, though there may be a mandatory provision in the statute directing payment of interest. In the facts and circumstances of the case on hand, there was no waiver either express or implied of right to claim interest. In view thereof, the decision of the Honorable Supreme Court in Pramod Gupta does not have any manner of application to the facts and circumstances.
Here also
of the
you said there was
instant
no
case.
waiver.
There was no waiver. This order has been carried in an appeal before Honorable Apex Court. It will be dismissed. I filed a contempt application. Finally, this amount was disbursed. Now, I made a representation.
That was regarding a corner in the same plot.
Rajesh Datta. Now, my lord, Deepali Maji, that is the appellant before your lordship, made a representation before respondent number 8. That is at page number 57. My lord, I'll read this whole letter because, my lord, there are few facts, my lord, which will be evident here from. Page number 57.
One representation was given by you on at page 46.
46,
23rd
yes,
of August. That was after Justice Basu's order.
after
And
Justice
he
order.
claimed interest there.
Claim interest.
And this is a reminder for that.
Exactly. Exactly. Page number 57. Please be informed that I am the owner of the land situated at so and so, so and so. A compensation was awarded for the same to the tune of rupees so and so by the Special Land Acquisition Officer, Paschim Medinipur, and competent authority under Section 3A of the National Highway Act on so and so. Since the compensation was not being disbursed, finding no other alternative, I filed a writ petition before the Honorable High Court at Calcutta being so and so, whereby Honorable Justice Biswajit Bosu was pleased to direct for release of such compensation on so and so date. Though I received such amount on so and so in my account, but the interest for such delayed payment was left out.
But the deposit compensation was paid within the time frame fixed by Justice Basu.
No denial on that point. On repeated occasion, I pursued into the matter and even filed a written representation on 23rd August 2021. That is at page number 46. But due to the different dilatory tactics played by the then Special Land Acquisition Officer Paschim Medinipur, my prayer was not acceded into. Since some of my other family members were making representation for payment of interest, all of us were called on a day of first week of November 2021 and told that we are not eligible to get compensation. We raised protest hearing the same, as it was within our knowledge that one Rajesh Dotto, who also happens to be our
footing as Rajesh Dotto. You are claiming on same footing as Rajesh Dotto.
Yes.
But your writ petition asked for interest that was not given to you. You did not challenge that. But you should have preferred an appeal against Justice Basu or a review.
My lord, that is exactly my point. My lord, your lordship.
No question of waiver here. You have not waived. But it's a deemed refusal of your prayer by a court. Worse than the waiver.
My lord, on that score, my lord, yes, on that score,
5, Section 11.
on that score, my lord, this my
was there
land
for
single
interest
judge
that
has
was
passed
not
with
allowed.
this order. Now, my lord, the question before your
The
lordship,
court
which-
appeal, we do have very little.
No.
We are not even the writ court.
my lord, now the question is the first that I haven't waived. Second, when the
No waiver. We are saying you have
when
not waived.
and
Same footing, agreed.
my lord, principal thing is that my lord Justice Biswajit Bosu has directed for payment. Payment has been done on a later date. Unless and until that amount has been disbursed, how can a person can calculate what would be the compensation?
The award of compensation was dated 27th of February 2019. So before Justice Basu, it was available to you to ask for compensation interest on delayed payment, because already there was a lapse of 2 years.
Yes.
About 2 years. And you asked for that in the writ petition.
Yes.
That was not given to you.
Yes.
It was
Malad, that-
directed by
Malad-
Justice Basu specifically that to take immediate disbursement of the compensation amount. No interest was mentioned, and we cannot assume interest being included in compensation because the
it
rate
has
is not given, date is not given. So
Exactly. If some
diffuse, deemed refusal.
if something has not been decided,
interest অনেক কিছু থাকবে।
if something has not been paid, this interest cannot be calculated.
Can we reopen the issue? It's only on res judicata, nothing else.
Your lordship would appreciate this part only.
We appreciate fully, but law is clear. Res judicata there has to be a finality of every proceeding. You could have preferred an appeal against this.
The order was, what is the difference between Rajesh Dotto and me? In Rajesh Dotto's case, the writ petition was
Face
pending.
different, skin color different.
What no was pending.
The only difference
in
between
this
you
case-
and Rajesh Dotto in law, insofar as this case is concerned, only difference is that Rajesh Dotto got an order of interest. You filed a writ petition, did not get an order of interest, there was a deemed refusal. That is the only difference between you and Rajesh Dotto, and that should have been the first ground of appeal against Justice Basu's order or review before Justice Basu. Go and do whatever you have to do.
I'll repeat this once again. If an amount has not been disbursed yet, how can the court can calculate? how can the court can calculate? Because this, Madam Justice Basu.
There's a basic
disclosed-
fallacy in that argument. When we ask for interest in a suit or anything, in any proceeding, we ask for interest till the date of payment. There is no question of calculation of what will be the interest. A prospective calculation is not there. We ask for interest because the rudiment of the cause of action has to exist on the date of making that claim. When you make that claim, there was already a delay of more than 2 years from the date of the award. So the award directed payment within a particular date, they failed that date, and the moment they fail, the delay starts. So as on the date when you filed the writ petition, you legitimately could have asked for interest. You did ask for interest because your interest, the interest granted by the court would be till the date of payment, obviously. But you could ask for interest because already there was an existing delay. So this argument that how could it be calculated? It won't be required to be calculated. If there is a delay, interest till date of payment.
There is another way to see it. Kindly come to.
Let
page
us see your
63.
prayer in the writ petition.
Yes.
No,
that
come
part
back.
is-
That was there.
was there.
That was
No,
there.
let us see if you can read there anything into that.
But that
Malad,
petition has not
that-
been
If you can give something to you on that.
No, there is another point. Acha, before that, that writ petitions.
Just the
prayer.
prayer portion of that.
Prayer
Have you annexed
portion?
that?
No, that
No,
has
Malad,
not been
they,
annexed.
they have annexed it with the reply. Opposition.
Opposition, acha.
Opposition is perhaps not before your lordship.
No.
Malad,
It is also with
uh,
the-
Where did it go? Where did the opposition go? You have filed an opposition?
yes.
filed the opposition
Before
in
the
the
single-
proceeding, but I do not have the opposition right
Oh,
now.
acha, acha.
Because after
You've got a
disposal,
copy?
I have handed up all documents to the authorities. madam. First prayer, my lord, last lines, and the second prayer also.
No, one page is missing. Any first prayer, last.
It was there. It was there.
Few lines.
It was
and
there.
the second prayer also, my lord, if you lordship can you have it.
Malad, now your lordship would kindly come
Go
to.
and file a review petition before.
Malad, kindly come to page number 63 once. 63 of the
Why
canopy.
did you file a new writ petition?
Malad, kindly come to page number 63 once.
Sixty-three.
63.
Yes, 63.
Petitioner pays for interest on delayed payment of compensation at so and so. Learned counsel for the petitioner submits that a similar issue was decided by a coordinate bench at 10% per annum.
So
Malad,
the
charges
first
also.
order passed in that same writ petition.
in this Deepali Maji's writ petition. The second writ petition. In view of the same, learned counsel for the state respondents seeks accommodation to submit an assessment of such interest. They have accepted.
Court,
One
apart from court, everybody accepted. Court did not grant it. You
Malad,
should have just taken out a 2-page review application before the concerned bench. You would have got an order.
they have accepted.
How can we say that interest has to be read into that direction of compensation?
Malad,
We would have to say that then, if you are to win this matter. Interest cannot be read into compensation since you have paid separately interest, which is the right thing to do. And secondly, if I grant interest, if the court grants interest, we have to specify the rate. Just directing to pay compensation obviously does not include interest because it has to be very specific. Interest at this rate or from such date. Now, it was not granted. Instead of preferring an appeal against that, you have taken out another writ petition, preferring an appeal against that. When Justice Chen's order came, you could have preferred an appeal still then. Go and prefer an appeal now before just against justice. Let the state suffer.
If
don't find any illegality in the order. Absolutely barbarous.
if my conduct of appeal, it's not my
Every
my
conduct has merged
client's-
into Justice Basu's order.
kindly see then their conduct as well. They have taken time on 3 occasions. They have every time they have
For what? They
stated-
did not concede. They said we will calculate interest.
Yes, precisely. That is my point. In view of the same, learned counsel for the
How
state.
can we reopen Justice Basu's order? Tell us that. It's a.
They have accepted that okay, they will
What are you
calculate.
saying? What sort of ridiculous argument is this? The defendant has accepted, but court does not grant the relief. So do you get the relief? You ask for eviction as well as mean profits. Say defendant even submitted that yes, we concede to mean profits. We are not speaking about order 12 rule 6. A regular decree, the suit is decreed, mean profit is not granted. You never prefer an appeal against that, nor a review application. That order becomes final, that attains finality. That is the principle behind res judicata. That relief you have asked for not granted, whatever may be their conduct, even if they conceded in express terms, we concede. What we could do if we were sitting in appeal over Justice Basu's judgment, we could immediately do that. Because we treat the appeal to be a continuation of the writ petition and we'll just grant that. We could record their concession, and that is the thing you should have done. We'll adjourn the matter, file an appeal against Justice Basu's order with a section 5. Go and do it. On the prayer of learned counsel for the appellant, let the matter stand adjourned till September 8, 2025. When it will be listed next under the same heading. File it, give them a copy, mention it.
Deeply obliged.
You're cultivators otherwise. Humble. Sorry for this.
Deeply obliged.
Grateful, my lord.
I'm for the petitioner. I'm praying for 1 day accommodation.
Why?
Tomorrow.
You move the matter. What is the matter about?
I'm for the state respondents. For filling up the post of FPS dealership, my lord. Notification was issued. Group 8.
Oh, essential commodity. Yes. You have a bad case.
No, my lord, good case, my lord.
You're led by somebody. Why are you asking for it?
Just now he left the
Who?
court. Mr. Lahiri, my lord, Subra Prasad Lahiri.
What do you say? Should you grant time? He's asking for 10 letters. If ultimately you decide that you will dismiss, he'll be embarrassed. If you allow it, no difficulty. Oh. So I will come back tomorrow. Please come. On the prayer of the appellant, the matter is adjourned for the day. Naam do book. Please give the names of us. Please give your name also. Not your senior's name.
No.
Maybe yellow.
Yes.
My lord, your lordship desire to give me 2 control orders to vote.
Okay. To have exchange copies of these documents.
My lord, your lordship, on the last occasion, directed my learned friend to supply certain documents.
Yes.
Which he wanted.
No
Document has been
we
supplied.
got it just now, my lord. That's why.
As usual. Then how can he argue on those, Mr. Dhar? You should have ensured it is given earlier. This is not the state of the art. This is art of the state.
Even today I got it.
Tomorrow, my lord, then
Mr. Agarwal, please come back tomorrow. Learned counsel for the appellant hands over certain documents which have already been circulated among learned counsel for the state. However, the state seeks to rely on certain documents, copies of which have not yet been handed over to the appellant. Have they handed over right now? Those copies of such documents of the state are handed over here and now to the learned advocate for the appellant. To enable the appellant to enable learned counsel for the appellant to come prepared on such documents, let the matter stand adjourned for the day.
Deeply obliged.
The documents handed over in court today be kept on record.
But I have some difficulty on
Tomorrow.
tomorrow. But day after tomorrow only.
Sagal, whatever you say. You have some difficulty day after tomorrow.
Not yet.
Not yet.
If I feel difficult, then I shall pray for time. Otherwise,
no, definitely. তাহলে ওটা ইয়ে করে দাও adjourn till August 21, 2025. পরশু থাকবে।
Deeply.
A judgment.
My lord, I have given the control order. Lordship can keep it because I have.
So we have recorded that the documents filed today are kept on.
No, my lord, these are not documents. These are the control order.
Acha, the documents and control orders handed over respectively by the parties today be kept on record.
Document means my lord, read petition. Then I am moving that.
Whatever documents you can come back on the next
day.
If you have circulated to them, then we can.
But that is read petition, nothing but
read petition. Contempt application, yes.
I am appearing.
You are the petitioner.
My lord's order your lordship will find at page 14. And the relevant, this is an order passed in section 24 Hindu Marriage Act application. My lord, kindly come to page 16, the relevant paragraphs 8, 9 and 10. At page 16, my lord. My lord, 10,000 rupees per month and towards areas of alimony.
Nothing has been paid.
Only 30,000. My lord, as of today, my lord, I have stated in paragraph, as of today, in terms of your lordship's order, my lord, the dues should be kindly come to
dues means after deducting what they have paid.
only 30,000 so far as has been paid. Only 30,000 loan litigation cost, no current alimony, nothing of the kind. Nothing of the kind. But I have stated that
You please
in
serve a
paragraph 11. Kindly come to paragraph 11.
We'll direct you to serve a copy and come back.
Of course, I have to.
This is for the first time appearing
This is for the first time.
So
Of course,
obviously
I
could
will.
not have served. A prima facie case of contempt has been made out inasmuch as the petitioner contends that in gross violation of the order of this bench of this court dated April 8, 2025, comma, a meager amount of rupees 30,000 has only been paid by way of alimony and arrears of alimony to the petitioner wife, comma, which is much below the amount directed. Full stop. That apart, comma, no further current payments are being made. Full stop. Thus, comma, the petitioner shall serve a copy of the contempt application on the alleged contemner, indicating that the matter shall next be listed on September 8, 2025, when an affidavit of service to that effect shall be filed by the petitioner.
Only two things. Now, kindly record litigation cost as direct has also not been paid.
Much কি বললাম একটু current payment and or litigation costs.
Not only one more indulgence. Not in earlier occasions, there are number of orders in the file that the presence of the husband was directed to be ensured by the concerned police station.
No,
Not
this is
in
for
that way, I am only submitting to the husband as well as the advocate on record. Only this. I'm not asking for anything.
Husband did not.
No, on two earlier occasions, not pursuant to the order of the
আচ্ছা
division
ঠিক
bench
আছে
and the advocate on record.
Serve a copy of the application on the alleged contemner and slokor the learned advocate appearing for the alleged contemner in connection with the present appeal. The appeal is still pending.
Yes.
In connection with the present appeal.
No. Appeal is pending. Let's have kept the appeal pending, and he appeared on the last submission. Appeal is pending. Appeal is pending. I'm grateful.
Thank you. Yes.
Appealing led by Mr. Ghosh.
Yes.
So Mr. Jay is leading.
Pardon?
Mr. Jay is leading.
Yes.
That matter, your lordship, section 14 M5 and 6.
Yes.
Lord, I sought for accommodation last occasion, Lord.
Right.
So clarify the matter. Now, my Lord, your lordship is right that there is distinction between section 5 and section 6. The land reforms act section M5 and 6.
Land Reforms Act are or Estate Acquisition Act. Thank you. ল্যান্ড রিফর্মস রুলটাও দিয়ে রেখে দিন একটু বাদেই লাগবে আবার তখন আবার তারপরেরটাই Yes. What is your grievance in this? Just remind us.
Lord, yes, Lordship, what happened, Lord?
Yes.
The petitioner's Lord, executed a deed of endowment in favor of the deities.
Idols.
Deities. But during Estate Acquisition Act, but under section 6(1), there was adjudication upon inquiry that it is purely a dedicated property in favor of deity. Accordingly, deity's name was recorded as a riot under the provision, and according to the provision of law, Lord, deity is entitled to maintain a property as per ceiling limit. Lord, that was provided under section section 14M, 1, your lordship will get it.
Yes.
Section 14M, in case of other rayat, 14M E.
Yes.
7 hectares.
7 standard.
7 standard hectare.
Yes.
But what happened? There was amendment. By amendment, these two has been introduced, section 14M5, M6.
14T, M.
14M. 14M5.
Oh, yes.
14M5 and
And
14M6.
And 6.
But in 5, it has been said that when the other than of a public nature,
Yes, yes.
lands owned by a trust or endowment other than a public nature shall be deemed to be land owned by the author of the trust or endowment, and such author shall be deemed to be a riot under this act to the extent of his share in the said land, and the share of such author in the said land shall be taken into account for calculating area of lands owned and returnable by such author. Lord, deed is personality goes.
But if it's public, it holds.
But if it is public, my lord, in section 6, as rightly pointed out by my lord last occasion, that in case of public, it will be entitled, he will be treated as a riot and entitled to retain 7 hectares of land. Lord, I was referring to the judgment of this Honorable Division Bench, Coordinate Bench, Lord, that Bhumijivi's case.
Bhumijivi, yes.
Lord, your lordship, I pointed out that section 5 has been scrubbed down.
Yes, you are to show that.
Yes. My lord, kindly see that judgment.
Yes.
Paragraph 189. I referred to.
189, yes.
189, Lord, it starts the page. Yes. Yes. Lord, 89, before 89, your lordship, 187. 187 paragraph, Lord, that has been quoted, section 5 has been quoted.
Yes.
Then 188. We have noticed earlier that the revenue officer is empowered to consider the question as to whether a trust is a public trust or private trust. But in view of our finding, there cannot be any doubt that once a trust has been declared to be a public trust by a competent court of law, the said question cannot be reopened. It is tied that revenue officers are bound by the decree passed by a civil court, but the converse is not true. Yes. Next, Lord, kindly see, this is the paragraph, this is important paragraph. Here, their lordships, what they have held. There cannot be any doubt that an idol created under a trust, be it private or public in nature, is a juristic person. Well, kindly note it, and is capable of holding property. Where a person dedicated its property in favor of an idol by creating private trust or public trust, the idol becomes the owner thereof. The same would be the position as regards other charitable or religious trust. In terms of the provision of West Bengal State Acquisition Act, the idol comes within the purview of definition of intermediary or tenure holder, and its property is vested in the state. Its position is the same in the eye of law as that of any other intermediary. Therefore, individual intermediary and idol are the same footing. In relation to the land, which are permissible to be retained under the Act means not Land Reforms Act. It becomes a tenant under the state. As indicated hereinbefore, riot has been defined in section 210 of the Act, not section 210 of the Land Reforms Act. Here.
Yes.
To mean a person or any institution holding land for any purpose whatsoever. Your lordship kindly note it. Once a trust or an idol becomes a riot for the purpose of the said act, the question of divesting its interest and creating an interest in respect of the lands owned by it in the author of the trust, in my opinion, cannot be sustained. This is the division bench finding. Therefore, section 5 goes.
With due respect, Mr. Ghosh, division bench did not take into consideration 14 M6.
6 has been dealt with.
Show us that.
Lord, Lord, what happened?
That has to be scrapped then.
Yes, no, that has not
Because
been.
this does not say that 14M5 is ultra virus.
No.
This is the opinion of the
The
judge.
opinion, they held that.
Not held to be ultra virus. Virus was specifically
But that
challenged.
cannot be sustained. But this is the finding, it cannot be sustained. It should be merged with the.
Where is that? Yes.
Yes, that it should be merged with
Answer
the,
trust.
the creators.
Becomes
feeling-
the right for the question of divesting its interest.
Yes. Creator of the trust, that has been not.
In my opinion, cannot be sustained, has not culminated. Because if you say, you have to specifically declare, Mr. Ghosh, that a particular provision of statute is ultra virus. It's a very serious thing.
Well, I-
Declaring law declared by parliament or legislature to be ultra virus is a very serious thing. We go on the topmost priority because we are not elected representatives of people.
Well, I know.
Obviously, you know.
But here-
Therefore, we have to, unless we spell it out, that for this reason we are holding that it is ultra virus. We cannot deem a declaration of ultra virus into a judgment. And it's settled that a proposition, a judgment is a proposition for whatever has been held, not what can be inferred therefrom. Which is you, Mr. Ghosh, you have cited so many times.
Lord, my lord, your lordship kindly thereafter, their lordships have discussed the matter and were so far section.
But stopped short of saying that 14M is ultra virus.
Lord, that has, Lord, I have not found that. That is not there. But this has been done, and in support of this, their lordships have assigned reasons in the subsequent paragraphs. Your lordship kindly see. It cannot be sustained. I am now reading 189. The same would amount to deprivation of property of a juristic person, which cannot be done without payment of compensation if the land is within the ceiling limit without payment of market value thereof. Next, 190. An author of a trust might have dedicated the properties in favor of an idol by creating a trust. Long back. Lord, here also, your lordship will find that trust was created, this endowment was in the year 1946. And the said act does not contain any provision for vesting of the estate of a riot, which would thus include an idol or a private trust. For the purpose of ceiling area, therefore, the idol cannot be divested of its properties, and the author or its successors in interest cannot be deemed to be the owner of the property. Now, Lord, what they say that by issuing a notice, they want to calculate the land of the deity with
As your property.
As my property. Therefore, the idol cannot be divested of its properties, and the author of this author or his successors in interest cannot be deemed to be owner of the property. Under the Constitution, a riot is entitled to full compensation if his land within the ceiling area are acquired. If such a provision is given effect to, the same would become self-contradictory. However, there cannot be any doubt that only in a given case where a private trust has been created in order to avoid ceiling limit, the appropriate authority may become entitled to tear the veil with a view to find out as to whether the trust in question is a genuine trust or not, and only in the event of a finding that the trust in question is not a genuine trust but has been created for the purpose of evading the ceiling area, the revenue officer may hold that in truth and substance the author of the trust, the owner of those lands held in the name of trust, should be held to be the land available at the hands of the author or his successors in interest. In other words, such inquiries are possible where there exists material to show that the transaction has been entered into with a view to defeat the object and purport of ceiling law. It is now well known that fraud vitiates all transactions. Next, Lord, next paragraph. 191. Some support of our aforementioned finding may be derived from a recent decision of the Supreme Court in such and such, wherein explanation 2 of section 222 and section 76 of Andhra Pradesh Charitable and Hindu Religious Institution and Endowment Act 1987 was questioned. The contention raised was that a right having been granted to the petitioners under the Andhra area Imams Abolition and Conversion into Rayatari Act, and the same having attained finality, the legislature is deprived of power under the Act to set at naught the effect of the grant of Rayatari Patta to the Orchokers, service holders, or employees covered under the Act by legislative sidewind, inasmuch as by reason of such Rayatari Patta they became absolute owners. It was contended that by employing a non-obstante clause, a vested right cannot be taken away without compensation. The question arose whether the legislature, by sidewind without suitably amending the Imams Abolition Act as interpreted by the High Court or repealing it, could directly nullify the law laid by the court and divest under section 76 of the Act. The vested right and declare that land was not covered by the said Rayatari Patta or shall not be transferred or shall be deemed never to have been transferred thereunder and would treat such person as an encroacher. The apex court held it is settled law that repeal of an act divesting vested right is always disfavored. Presumption is against repeal by implication, and the reason is based on the theory that the legislation, while enacting a law, has complete knowledge of the pre-existing law on the same subject matter. In the principle of statutory interpretation by Justice G.P. Singh, such and such, at pages such and such, under caption reference to other statutes in chapter 4, external aid or aid to constructions, it has been stated that the legislation proceeding upon an erroneous assumption of the existing law without directly amending or declaring the law is ineffective to change the law. The beliefs or assumption of those who frame acts of parliament cannot make the law, and a mere erroneous assumption exhibited in a statute as to the state of the existing law is ineffective to express an intention to change the law. If by such a statute the idea is to change the law, it will be said that the legislature has plainly misfired. The legislation founded on the mistaken or erroneous assumption has not the effect of making that the law which the legislature had erroneously assumed to be so. The court will disregard such a belief or assumption and also the provision inserted in that belief or assumption. A later statute, therefore, is normally not used as an aid to construction of an earlier one. Now, Lord, the court also considered that without amending the law under Imams Abolition Act and without properly removing the foundation of the judgment rendered by the High Court, and the legislature cannot seek to destroy the effect of Imams Abolition Act on an erroneous belief or assumption that it did not bind the religious or charitable institution or endowment, or that the holder of the land.
In this photocopy, page 344 to 345, 344 and 345 are not there.
Lord, your lordship, that
If
was
you-
a mistake. Your
In
lordship.
your copy also, if later on it
Same-
can be provided, we
same
shall
thing.
insert it.
Lord, I can.
Please
Your
just,
lordship can be.
you've got extra copies?
Yes. Lord, yesterday, Lord, we have
You
checked.
anticipated.
I find. And it's fine.
But this is 44 and 45 is also not there.
Yes, Lord, I'm giving. 45. 44 and 45 both are there.
Yes. We have got one set of 44 and 45.
Yes,
You
45.
hand over the other set for my lord.
Lord, your lordship got two
Yes.
sets.
Now got.
Lord, now your lordship can see in the 45. 44. Yes. Now, Lord, they did not acquire title or patta which was granted to him, and the land was still with the institution and treated the occupation as encroacher. It therefore held that the provision to be unconstitutional. In the instant case, West Bengal Estate Acquisition Act had not been repealed. Under the West Bengal Estate Acquisition Act, charitable purpose and religious purpose has been defined. The definition of intermediary is also wide amplitude. Section 6(1)(I) entitles an institution established exclusively for a religious or of a charitable purpose or both to hold the land like any other intermediary. In terms of West Bengal Estate Acquisition Act, therefore, they also become tenants of the state of West Bengal, and in relation to the agricultural land, a riot. Section 10, 210 of the West Bengal Land Reforms Act contains the definition of riot, which is also of wide amplitude. Thus, there cannot be any doubt whatsoever that the religious or charitable institution having become a tenant under the state and thus having been granted statutory right to hold, retain, and dispose of lands cannot be sidelined and deprive its properties for any purpose whatsoever. Now, Lord, your Lordship kindly see Section M6. Thereafter, Lord, the Honorable Supreme Court, Mr. Gupta, however, has raised upon a decision, has relied upon a decision of the Supreme Court in such and such, wherein the observation has been made that it is only in an ideal sense that the idol is owner of the endowed property, as it cannot make itself use of them, nor can enjoy or dispose of the same, or even protect them. The Supreme Court itself, in that decision, held that idol can have no beneficial interest in the endowment. The decision of the Supreme Court must be read in fact of the said case. However, there cannot be any doubt whatsoever in view of the settled principle that idol is a juristic person and can own property and dispose of the same through the service. An idol loosely is also called a perpetual minor, although the terminology is not correct. Like any other juristic person, it can enjoy the property itself or dispose of the same unless the person managing the affairs think fit to do. They act on and behalf of the idol and takes a decision in this regard, in that regard, and that does not mean that a body, corporate, or an idol would not be entitled to own the property. However, so far as Section 6, M6, Lord, next paragraph M6 has been discussed.
M6 has been retained.
That has been written, Lord, because Lord, that is
Because that is not against what was.
Lord, that we are not related to Section M6.
Mr. Ghosh we have an opinion on that. We are just telling it to you. All said and done, 14M5 was not held to be ultra vires by this judgment. Now, Mr. Ghosh, we are fully aware that the judge who authored this judgment is much more erudite than either of us. At least I can speak for myself. No,
Yes,
he was. But Mr. Ghosh, we have a different take on that. Now, when we consider, I'll just complete and then you give your answer to that. When we are considering the virus of a legislature, as we told, we are not the representatives of the people, courts are not. So we have to be on a higher footing than executive action.
Yes.
Now, legislature is entitled to represent the people, aspirations of the people. If it goes against a law palpably contrary to some legal principle, we have a right to, or against the constitution, then we can do it. Now here, a concept is being discussed, was being discussed in Paschim Banga Bhumijivi. This is a legal fiction that an idol is a perpetual minor, and an idol which is otherwise without your faith, an idol is just another object.
Yes.
If I may use that expression, without hurting your sentiment. So otherwise it would be just an object, physical thing. Our faith makes the legal fiction that it's a perpetual minor. It can hold property.
Yes.
Now, whether the legislature is justified in distinguishing between a public trust and a private trust, because both are legal fictions. Actually, the idol is not doing anything. It's the people who are reposed with the power. We are of the opinion that legislature can do it, distinguish between a public trust and a private trust vis-a-vis retention of land. Why we say this? In case of a private trust, for all practical purposes, it's in the family. The usufructs of the property of the idol remain within the family, enjoyed by the family, cannot be transferred, cannot be done something, but that also can be done with the leave of court.
Yes.
So usufructs are ultimately enjoyed by that riot, the person, the settler and his family. Unlike a public trust, where usufructs might not be enjoyed by one family or the riot only. It is a public trust, so it's open for the public to have a say in that. So therefore, when we consider whether regarding retention of land, in case of a public trust, although idol is the owner, but ultimately the ownership is diluted because other people have a say in that. But in case of a private trust, theoretically deity is the owner. But what happens is that Rayat himself and his family are enjoying the usufructs. And for all practical purposes, that land which belongs to the private idol, I mean the private trust idolity, it's being used by the Rayat. So he cannot take advantage of the ceiling by dissociating the idol's property from his, because it's the Rayat at the end of the day who is enjoying the entire usufruct. So that is a reasonable basis of distinguishing between 4M, 5 and 6. Even if both cases idol is a legal fiction, it's a DT, the DT is the owner. But in public trust, the accountability is much wider. Other people also enjoy. But in private trust, for all practical purposes, it's a Rayat who is enjoying. That's why there is a reasonable basis of this distinction. If there is a reasonable basis of distinction, Article 14 cannot be applied to the legislature, to a statute as such. So therefore, there is a reasonable basis of this classification in this amended 14M 5 and 6, Mr. Ghosh. There we have a slight deviation from this Paschim Banga Bhumijivi opinion that no, public trust, private trust cannot, because the division bench in that case also holds that the veil can be pierced. So it's a veil, it's a fiction that can be pierced if for the purpose of avoiding it has been done. But we go one step further, even without avoiding, because it was created long back. At that point of time, there would not be anything in the mind of the Rayat that I would be avoiding. No, definitely not. But by its very nature, a private trust created for a DT is, for all practical purposes, the Rayat is using the usufruct. So therefore, that distinction could be reasonably made and has been made. So that is probably the reason why the division bench stopped short of declaring 14M 5 as ultra vires, Mr. Ghosh. So if there's a reasonable basis, we have to go by the statute, and the statute has not been declared by.
The question is raised by my lord. Lord, it has been discussed in a Supreme Court case.
Achha.
Lord, that is in relation to Estate Acquisition Act. There, the plea was taken that it is utilized not for religious purpose but by the Sevites. That has also been turned down by the Supreme Court, that it is still deity's property and deity can retain it.
Remains that. In law, it remains that. But for the purpose of this ceiling limit, counting of ceiling limit, now ceiling limit is another legal fiction. I mean, ceiling limit, it's imposed by the statute. That is public policy. So while imposing ceiling limit, we have to assess, because that's a right conferred by the Act to retain. It could have been taken away by the legislature. But for certain persons, it is permitted to be held. That ceiling limit, if it's used as khash by that person itself. But deity's property may not be deemed to be that, I mean, but the usufructs are being used by them. It's
But here also the first inquiry under Estate Acquisition Act, it has been in detail it has been held that the usufruct of the property is utilized for deity's purpose only, and there are other expenses regarding to feeding the poor and distributing clothes and rags, etc. That has been held by the.
But again, as Mr. They pointed out on the last occasion, 14T6 and the other provisions that it can be reopened.
Lord, if this opinion is there, this regarding section 14.
No, tests of Estate Acquisition Act are different from 14M 5 and 6.
Yes.
Estate Acquisition Act does not distinguish between the two, public and private.
If it is a held that it is a juristic person, it can retain land, it has vested to it, whether it can be divested on the plea that.
But 14M6 comes in.
14M6, Lord, your lordship can see.
5 and 6 both are there.
14M6 has been discussed in this judgment.
14M6 has been supported because that is in consonance with
yes,
justice.
State can do it. State can do it.
But
it has no relation with section
14M 5 has not been struck down.
No, not, but it has been not discussed and said that it cannot be.
By implication, there cannot be any striking down by implication. A virus of a statute, it remains in the statute book.
But Lord, this is the opinion of another coordinate bench that it cannot be.
Opinion, we appreciate the opinion. Even if we agree with the opinion, the statute remains.
Yes.
They in law could do this.
And Lord, this matter still sub judice before the Honorable Apex Court.
That does not. Apex Court is regularly saying just because it is sub judice before us, you cannot use that as an excuse to shirk adjudication.
It is not.
So that's where we are having a difficulty in.
And regarding res judicata also, 14T6, it has been that 14T9. 14T9. That has also been discussed here, that it cannot be taken away. Principle of res judicata.
Where has it been discussed?
Lord, paragraph 114. of this judgment. 135, my lord, can you see?
135.
Lord, your lordship would get it at page 320.
135.
No, 320, page 320 of the judgment. Paragraph 114. Starts from 114, Lord.
Yes.
Section 14T6, 8 and 9. Read thus, it has been quoted. Thereafter, Lord, Section 14T confers a duty upon the rayos to furnish returns in terms of subsection 2. Such returns has to be filed by the head of the family or any other rayos where there are more rayos than one in the family. Subsection 3 of the 14T provides power to the revenue officer to determine the extent of land which is to vest in the state under section 14S. Yes. Subsection 3A empowers the revenue officer to revise an order made under subsection 3 on his own motion after giving the riot an opportunity of being heard. 170. The subsection 4 of the 14T provides for consequences of failure to file return in terms whereof he makes himself liable for punishment with imprisonment, such and such. Next, subsection 5 empowers the revenue officer to determine the question of benami. The said provision has been declared alta viris by the learned trial judge on the ground that the same is in conflict with the Benami Transaction Prohibition Act, which has been enacted by the Parliament. But the said question has otherwise been decided by division bench in such and such case, Calcutta Law Journal. The question as to the viris section 14T5 would be considered later on. Subsection 6 of section 14T empowers the revenue officer to consider question as to whether any trust, endowment, or institution is of public nature or of exclusively religious or charitable in character, or both, and any question of title incidental thereto, as may be necessary to determine the extent of land which is to vest to the state under section 14S by examining the documents, if any, or by taking into account the factor enumerated therein. Subsection 7 provides for an appeal by a person who is aggrieved by an order under such and such. So far as the subsection 6 of section 14T is concerned, the only submission made on behalf of the learned trial judge before the learned trial judge was that the revenue officer are not competent to deal with the complicated question of law. However, such a question has not been raised before this bench. The learned trial judge proceeded on the basis that as subsection 5 was alta viris, subsection 6 cannot operate, as in fact same would be futile exercise, as ultimately ceiling limit has to be determined under West Bengal Land Reforms Act. There is no law which disentitles an executive officer to determine a question.
134, 135 probably are, as
Yes.
Mr. Rai was pointing out. Those are more German on this.
Yes.
134 onwards.
Yes. Yes.
But that applies to judgments of court, which cannot be.
Yes, not that I have seen.
But it's not a question of reopening its own order. Judgments of court have a different footing.
The submission, Mr. Gupta,
That has also been discussed, not a judicial officer and all these things. So a non-judicial officer should not be permitted to reopen the judgment of a court of law. Unless the statute specifically provides, there are certain statutes. Mr. Ghosh, irrespective of judgments of courts and all, now the new statutes are mostly that.
Lord, kindly allow me to place page paragraph 135 once.
Yes.
The submission of Mr. Gupta to the effect that the revenue officers have given power to reopen cases and not to nullify any judgment is wholly misconceived. Principles of res judicata as admitted by Mr. Gupta is founded on consideration of high public policy to achieve two objectives. Namely, there must be a finality to the litigation and that individuals should not be harassed twice over the same kind of litigation. Such and such judgment, paragraph 13.
The example given is in a civil suit.
Yes. Lord, you also can see for a detailed discussion on the subject, reference may be made to a recent judgment of such and such counsel reported in judgment today. The instances of successive habeas corpus application before the English court as an example cited by Mr. Gupta cannot have any application.
Civil court cannot be reopened by revenue officer. We agree.
Yes. By way of example, it may be noticed that if in a civil suit a trust has been held to be a trust of public nature, the revenue officer in purported exercise of the jurisdiction under subsection 6 of section T, 40, cannot ignore this decision and hold the same to be a private trust. Similarly, a question of title decided by the civil court cannot be reopened by the revenue officer on the ground aforementioned. Moreover, subsection 9 cannot be held to have conferred any arbitrary or unguided power upon the revenue officer, who is an executive officer, to reopen any or every question he likes. Such a power is held to be available at the hands of the executive would be ultra vires under Article 246 of the Constitution of.
It has been read down.
Yes.
Reopened only when it is necessary to give effect to the provisions of 81 and 86 amendment.
Yes. Eventually, thus, the legislature has no jurisdiction to lay down that without any more judgment or decision or award of any court shall not operate as certificator. More so, in a case where state is a party there. Now here also, Lord, the state didn't challenge either the first order or the second order by which the revenue officer under West Bengal Land Reforms Act issuing a notice under section 14T3, under 14T3, Lord, determined that the ceiling limit of the creator of the endowment.
Mr. Ghosh, in the last sentence, the division of para 135, the division bench holds, in such view of the matter, in our considered opinion, provisions cannot be upheld on the ground giving effect to directive. In this view, the very last sentence of para 135.
Yes.
In this view of the matter, we are of the opinion that the said provisions have to be read down so as to confer jurisdiction upon the revenue officer only to the extent that question may be reopened only when it is necessary to give effect to the provisions of 1981 and 1986 Amendment Acts. Now, it is the amendment of 14M 5 and 6 which has been sought to be given effect to by way of this reopening. So, it is squarely covered by this reading down also.
Yes.
Even if it is read down, that a reopening can be done only to give effect to amendments. That is precisely what has been done here.
Here also it is the opinion. It is not struck down. It is the opinion. There also, Lord, same thing, opinion. It is my opinion.
No.
Yes, Lord.
No.
Section 14.
We are telling you.
Yes. In view of the matter, we are of the opinion.
In our considered opinion, the said provisions cannot also be upheld on the ground of giving effect. In the other paragraphs, there is no mention, no whisper of any provision being upheld or not. Here it has been held. In this view of the matter, in our considered opinion, the said provisions cannot be, the previous sentence is such a power if held to be available would be ultra vires. In this view of the matter, in our considered opinion, the said provisions cannot also be upheld on the ground of giving effect. Then, next, in this view of the matter, we are of the opinion that the said provisions have to be read down. So that is one of the policies adopted by the judiciary. If we feel that otherwise a provision would be ultra vires, it can be saved by reading down, we read it down. That has been done. Read down. So this is the ultimate proposition laid down.
Read down, they are also, they are not saying that it is
have to be no.
But
reading down is not ultra vires.
That is so. That's why.
Let us read this together. In this view of the matter, we are of the opinion the division which has read down that the said provisions have to be read down so as to confer jurisdiction upon revenue officer only to the extent that question may be reopened only when it is necessary to give effect to the provisions of 1981 and 1986 Amendment Acts and not otherwise.
Yes.
So the ratio laid down here is to give effect to amendment if it is done, that is legitimate.
In appropriate cases.
Not in appropriate cases.
That is not read down. That's why read down. It has been
not appropriate cases. Only if it is necessary to give effect to amendments. Here it has been reopened to give effect to the amendments of 14M 5 and 6.
And Lord, here also.
So this is covered by this judgment. This judgment sanctions it.
And paragraph 189 also, Lord, it is their opinion. The Lordship kindly see once that my opinion cannot be sustained. The same would amount to deprivation of the property of a juristic person. Same thing. In similar terms. Therefore, Lord, if it is said that it has not done, here also it should be read down.
No provision was referred to in para 189.
Yes, there are 189 the provision for this, and ultimately said that Estate Acquisition Act has not been.
Language is entirely different. A language in 135 is in this, because before that it starts with moreover subsection 9 cannot be held to have conferred any arbitrary or unguided powers. Next sentence, in this view of the matter, in our considered opinion, the said provisions cannot also be upheld, and again said provisions have to be read down.
Yes.
Unlike that, in 189, no said provision is there. General proposition is laid down.
Yes. But here also there are
Here it is said, once a trust or idol becomes a riot, the question of divesting its interest and creating an interest in respect of the lands, in my opinion, cannot be sustained.
Yes.
Same would amount to deprivation.
Yes.
But no provision is read down, no provision is mentioned even.
Lord,
A
here-
general proposition has been laid down.
And Lord, there,
It's a general discussion.
Their lordship, in the next paragraph also it has been clarified where it can be done.
Show us one provision, if such a provision is given effect to, yes, you are right. 190 it is there, referred.
Yes.
If such a provision is given effect to, the same would become self-contradictory.
And Lord, ultimately, in which cases?
But then also it's
Lord, kindly see, they are ultimately.
this is a bit unhappily, because in a sense, because it has been said that only in a given case where a private trust, court itself says it cannot be, it will become self-contradictory, but creates an opening that in these circumstances it can be done without reading down this provision.
Yes, reading down. Here the same.
Reading down is a specific language like
Lord, I know,
ultra-virus.
reading down is specific language where.
Like ultra-virus.
Yes.
We say that we read down the provision to this effect, or we declare it ultra-virus.
Lord, ultimately, Lord, their lordships also held that where this can be done, where it is for the purpose of avoiding ceiling limit.
Without reading down any provision, that is not specifically stated here. That is the difficulty.
And Lord, also it has been said that the law is still there.
We are reading down what you are saying and declaring what Mr. Rai is saying ultra-virus.
Lord, and Lord, your lordship, same time, considering the Honorable Apex Court judgment, their lordships have held that the Estate Acquisition Act has not been repealed or amended. Amended is still there. Therefore, something else cannot be done. And Lord, that has been held by their lordships upon considering the Honorable Apex Court judgment, that Andhra Pradesh Abolition Act. Justice Ajit judgment. But 2010 Supreme Court, cases, there also this question arose, not under the West Bengal Land Reforms Act with regard to the provision of amended provision. That is single bench judgment, Lord. Here, Calcutta High Court, Honorable Justice Ajit Kumar Sengupta. এখানেও লিখেছে section 14M Land Reforms Act provides the land owned by the. But though it is single bench, Lord, it has been discussed by Justice Ajit Kumar Sengupta 14M5.
What has been held? Ultra-virus?
But it cannot be reopened.
You cite it? Yes. Definitely. Why not? Give the citation to me.
Lord, it has been reported in 84-1 CHN, page 104. 88 CWN, 435.
But Mr. Dey, you will have a right of reply to this judgment. No, there is no reply to reply, but since it's a new judgment being cited, we want to be very liberal on that. If some judgment is cited,
he can
cite any judgment.
Cited any judgment, my lord. As because, my lord, this is a new act.
No,
Independent act.
we'll
So
hear.
I must not say anything, my lord. As because, my lord, according to the provision, that is, after that, I have no any right to say something.
No, only if he cites a new judgment, you can reply to that.
No, my lord, I may not want to that matter because that is both the act, my lord, independent act. So independent act.
If there's an adjudication under one act.
Yes, my lord. West Bengal.
So, Mr. Dey, what he's saying is if there is an adjudication under the Estate Acquisition Act, it's an independent act. So how can you override that by virtue of a new
act? Because there is the provision that is legislature wants to add those say 14T, 656 and other things, my lord.
And as per the language,
not that.
And as per the language of 14T 5 to 9.
According to my learned friend, my lord, that is the estate, if there is any order of the Estate Acquisition Act that is 25 bighas to 15 bighas and 5 hectare, then I can't come to the, my lord, that is only 7 hectare. From the 25, that is coming from 7. I can't come with that provision. I never starts any proceeding of 14T, my lord, according to my friend.
Yes.
If I can
Start a proceeding, then you can do it.
everything will be done in for the cause of the legislature, my lord. This act was, my lord, created by the legislature, not by I or Mr. Gopal Babu. So, my lord, it is Gopal Babu what wanted to submit before your lordship, that is not, my lord, reflected in our case, in this case, my lord. And my lord, that is a 2 different bench, my lord. That is 1 division bench, that is another division bench can't go into the merits of the case, whether that is done or not. My learned friend said that you have not any right to go there, as because there is this, there is that, but there is nothing, my lord, as because the entire order, my lord, is based on only one, that is 14, that is only compensation part, nothing else, my lord. So, my lord, I may not want to submit anything, my lord. Whatever my learned
Lord,
friend
yes.
said, he can.
Lord, they can very well initiate a proceeding for determine what the area of land the deity is retaining. That can be done. If it is more than 7 hectare, they can take away.
Mr. Ghosh, you say there is no repeal of Estate Acquisition Act. Agreed. But 14T9 is precisely that.
Section 5, 6, 7.
5 to 8 of this section shall be deemed to have always been inserted in the West Bengal Estate Acquisition Act.
Yes.
That is the language used.
Yes, no.
14T9. That these sections shall be deemed to be inserted in the West Bengal Estate Acquisition Act.
Yes.
So therefore, even without repealing that act, these have been inserted, thereby inserting a power of reopening into the Estate Acquisition Act itself. That is what has been done.
But that whether
this is excellent bureaucratic drafting, actually.
Whether this can be done, I do not know.
We also don't know, but this has been done.
Yes. But it whether Lord, you'll now Lord, you'll also take the judgment I have given you.
Anyway, yes.
Paragraph 11. Once a revenue officer, upon consideration of all relevant materials and evidence, has come to a definite finding and conclusion in the proceeding under section 44(2)(a) and section 6(1)(i) of the Estate Acquisition Act, and has granted relief and or exemption in pursuance thereof, unless those are set aside and or reversed by appropriate appellate or revisional authority. Such finding and conclusion are binding on the revenue officer deciding a similar issue under the provision of section 14T of the Land Reforms Act. There must be some finality in the judgment or order passed by the revenue officer. A revenue officer under the Land Reforms Act should not be allowed to come to a contrary finding or conclusion on an identical issue determined earlier by another revenue officer under the Estate Acquisition Act, unprovoked by.
Of course, your reliance on Poschimbango Bhumijibi goes against you, because Poschimbango Bhumijibi in 135 says that this cannot be given effect to unless it is to give effect to the amendments of 1981 and 1986.
Yes.
And subsection 9 is inserted by virtue of amendment of 1981. Therefore, this is the specific scenario which has been exempted in Poschimbango Bhumijibi. It has been said if it is in pursuance of 81 or 86 amendment, it can be reopened. And this is precisely what has been done in the present case. Your subsection 8 is 86 amendment and subsection 9 is 81 amendment.
Yes.
That is sought to be given effect to.
সেটা বলছি।
So they will rely on 135 of Poschimbango Bhumijibi.
Yes. Lord, your lordship, this judgment, Lord.
Anyway, 11, Justice Sengupta's judgment is there.
Yes, next, Lord, 12.
Yes,
Section 14(m)(5) of the Land Reforms Act provides that the lands owned by a trust or endowment other than the public nature shall be deemed to be the lands owned by the beneficiary under the trust or endowment, and each such beneficiary shall be deemed to be a riot under the Land Reforms Act to the extent of share of the beneficial interest of the trust or endowment. Here, the lands are not owned by the trust or endowment. There has been an absolute devotor in favor of the 3 deities. The deities are the owners of the properties dedicated to them, as held by this court in case referred to above a DT being juridical person, juridical and an artificial person is a riot.
Mr. Ghosh, with due respect, with utmost respect, this judgment is par inquirium because it's in the teeth of the statute. Statute has not been held to be ultra vires. In the same breath, the court could not say that section 14M5 permits this, but this is against principles of law. I am not permitting it. This is par inquirium for violation of statute. This is not par inquirium in respect of a previous judgment. On the teeth of it, this is par inquirium because this court section 14M5 says 14M5 provides this, but I will not grant it because it's against settled propositions of law. M5 was never challenged, the virus was never challenged, nor declared ultra virus here. How can the court say this even? And we rely on 135 to say, we rely on 135 to say that these are the scenarios where Paschim Banga Bhumijibhi held that there can be reopening to give effect to the amendment. That has been done here. Shall close arguments, Mr.
Your Lordship, can Oh, 92, that is also a single bench judgment.
No, don't cite too many judgments in reply. In rejoinder, no other judgment. No
But
other.
I am not in reply. It is
No,
regarding limitation.
no other judgment. You should have cited it at the first instance.
But it was not concluded on that time. I was just discussing about that.
Oh, it's a very cited.
Second court. No.
Yes.
Lord, as my lord, felt from my lords that regarding the utilization of the property, they dedicated. Lord, this is a judgment of the Honorable Apex Court, 3 judges bench.
Yes.
That is reported in 2000, volume 10, Supreme Court cases, page 376. 2000, volume 10, SCC, page 376. Now, this is also a case. This is a case under West Bengal Estate Acquisition Act. But there the specific plea was taken that the income of the deities estate are being utilized by the persons, beneficiaries.
What is the proposition you are really? This is under section 6 of the Estate Acquisition Act.
Yes.
So what proposition you are really?
Lord, yes, Lord, here the question was raised that when the income is being utilized by the Sevites.
Any particular paragraph you can
Yes,
place
now
there?
telling me. Lord, paragraph 10, Lord, Your Lordship,
yes.
paragraph 10. The mere fact that the trustees or the Sebais may not utilizing the income of the purpose for which it was meant to be used cannot detract from the fact that the Devotor was established wholly and exclusively for religious and charitable purposes. These being so, provision of section 6(1)(I) were clearly attracted, and the Honorable High Court was therefore right in allowing the appeal and passing the order of settlement of it. So there
This is under the estate acquisition.
estate acquisition, but it fell from my lord this distinction that it may be in the benefit of the Sebais.
This does not have any precedentiary value on the on section 14(T)(9). That's a different
No,
statute.
I'm not saying that. The only thing, Lord, that your lordship that it is purpose.
No, we were saying something else. We are saying that might be a reasonable basis
Two things.
for the legislature to have done it. If there might be a reasonable basis, we cannot interfere.
Yes.
It's a legislation. And this was executive action done by the revenue officer.
And no, this is this is not this is a judgment of this honorable single bench. This is reported in 1992 Calcutta Law Journal.
Give us a copy of that.
Copy.
For what proposition?
Well, there is a question of limitation. When it can be reopened? Within which time?
Under which statute?
14(T)(3). Paragraph 14, Lord, can I'm giving Lord a copy.
What does it say?
Judging
Bring copies will continue after recess.
Yes, Lord, yes.
This is for 2 PM কিছু fix আছে?
And 14 were also partnered matters. That's a section 37 appeal. Mr. Jishnu Shah was.
Yes, we'll continue with this.
Only one submission. Mr. Shah has some personal difficulty this week.
You are not permitted to leave the keep somebody here.
Of course.
Whenever it is called on, keep somebody who will have to ask for time.
Not here. So the provision is that the revenue officer can
Yes.
to initiate a proceeding law for reopening.
Take the microphone a bit.
Yes.
Because, yes.
They can initiate suo proceeding from reopening the matter and decide the same. But in this connection, the coordinate bench case reported in 1992, reported in 1992, volume 2 CHN.
Take the microphone a bit lower, Mr.
Lord, yes. This is 1992, volume 2 CHN, page 32.
Yes.
Lord, paragraph 12.
Yes.
Yes. In the present case, the revenue officer concerned in the proceeding under section 14T3 as mentioned in annexure A to the writ application determined by his order number such and such dated 16 September 1976, the quantum of land to be retained by the writ petitioner under the West Bengal Land Reforms Act 1955. And the said order, therefore, can very well be said to be the final order passed in such proceeding. An appeal is provided under subsection 7 of section 14T against final order, and as no such appeal was preferred in the present case, the proceeding ultimately reached its finality with the expiry of the period of limitation for preferring an appeal against such an order as provided under section 54, read with section 55 of the West Bengal Land Reforms Act. Judging the fact and circumstance of the case and provision of the Act as well as the decision as referred to above, it can therefore be held that a lease or dispute regarding the question as to the determination of ceiling limit for retention of land by riots as per the provision of subsection 3 of section 14T of the West Bengal Land Reforms Act reaches its finality when the period for preferring an appeal as provided in subsection 7 of the section 14T read with section 54 and 55 of the aforesaid Act against determination of such ceiling limit by the revenue officer concerned expires. When such appeal is preferred, and where such an appeal is preferred, the moment the appeal is ultimately decided as per the provision of subsection 4 of section 54 of the Act. As such, the revenue officer concerned under section 14T3 can so move to revise an order passed under section 14T3 determining the limit, ceiling limit of the lands of riot is entitled to retain under the Act either within 30 days from the date of such determination or before the disposal of the appeal, if preferred against such determination, but no otherwise or not beyond such period. In the present case, therefore, the initiation of proceeding under 14.3K by issuing an impugned notice being annexed B to the petition having been made long after the aforesaid period of limitation was thus wholly illegal and not maintainable in law, being out of time, and hence the same stands quashed. But here also, Lord, the second determination was held in the year 1990, and this impugned notice, which we have challenged before your Lordship, has been initiated in 1995. This is another thing. So therefore, Lord, if your Lordship, we have challenged the notice, and there was an order of interim order passed by this Honorable Court, and ultimately, Lord, upon transfer of the writ petition to the Land Reforms and Tenancy Tribunal, it has been decided against us. Or held that is revenue officer power in view of.
Yes.
Therefore, Lordship, if held against us, Lord, then we should be given an opportunity of hearing so that we can.
Yes, you
But
want to.
Yes, the one decision about the one right is accrued that cannot be vested, cannot be divested. This is the settled principle of that is one of the aspects. But though in the West Bengal Premises Tenancy Act in a case, there is no retrospective effect. Your Lordship knows that judgment, Rajesh Kumar Mitra versus Karnani property, only that view of the matter, though the West Bengal Premises Tenancy Act 1956 has been repealed upon introduction of 1997 Act, but the right accrued of the tenant under the West Bengal Premises Tenancy Act 1956 has been restored. But though division bench of this Honorable Court held that yes, from the coming into operation of the Act, if dies 5 years from the date of coming into operation, if prior to that, after death, after coming into operation 5 years, and if prior to coming into operation 5 years from the date of introduction of this West Bengal Premises, but there was no retrospective. By here, There has been just proceeding.
মামলা আছে কয়েকটা। My lord, I do not want to, as because my lord, all the judgment is not applicable in my case. And my lord, intention of the legislature to, my lord, pass the West Bengal Land Reforms Act. My learned friend said that the Land Reforms Act is ultra vires, according to his provision, according to the legislature intention of the West Bengal State Act 1953. My lord, 1953 Act was my lord, enacted only for the cause of the, that is the Jamindari and other process. And for that reason, there is some lacuna. For those, my lord, after that, my lord, the legislature thinks that this is not always applicable to the general people. For that reason, West Bengal Land Reforms Act, my lord, came into force, my lord. And 14T, my lord, previously, my lord, there is no any before 14T3A, my lord, amendment, there is no any, my lord, revenue officer has not any right to reopen the case. But in this case, my lord, that is not 14.3. If your lordship recollect, my lord, if your lordship will recollect that 14T, last order of the 14T, it is not the purview. Some lands in the name of the deities, and my lord, that land, it is not the purview of 14T3. For that reason, my lord, he dropped the proceeding. And after that, my lord, we issued the third notice, 14T6. And 14T6, my lord, 6 to 9 was amended in 1981. And 14T5, my lord, was amended in 1986. For that reason, my lord, that is the amendment was done and other things, my lord. So, my lord, intention of the legislation is there to enact the Act of West Bengal Land Reforms Act, and there is no any, my lord, contradiction between the two acts, my lord. Only to, my lord, to, for that reason, my lord, the petitioner has not any case, my lord. I may not want to take much time.
Result.
Yes, my lord.
Heard learned counsel for the parties. The hearing is concluded. The matter is reserved for judgment. Thank you.
ইয়েতে 42 আছে, চললাম না, হয়নি
এটা না
একটু সময়
কলকে বলে দিতে হবে যে এস্টেট অ্যাকুইজিশন একটা ল্যান্ড রিফর্মস একটা যেন ওখানে থেকে দিয়ে দেয়, আনিয়ে যেন আমার এই ফাইলে দিয়ে দেয়। This matter probably he has some difficulty.
Yes, for Mr. Shah has some difficulty.
Mr. Shah is for the respondent.
Yes, for the respondent.
So you are appealing for the appellant. He said, mentioned in the morning.
No, Milan, only thing is this, Milan, I am told on instructions that they are pressing very hard for the execution of this award while it's being heard.
No, Milan, we should not. Milan, since it is being heard.
When should you keep it?
Next week, any day. Or Friday. Milan, if it could be kept on Friday. Next
Friday is we sit singly.
Oh, yes. Next Tuesday. Well, any day next week.
25th Monday. On the prayer of the respondents, the matter is adjourned till August 25, 2025. Mr. Dutt, if something happens in between, please mention, just intimate us on one.
My instruction is that we are not pursuing the execution at all. But even if it comes up, we will not press for it because the matter is being heard.
Yes,
grateful.
Passover.
Captain, I filed the affidavit of opposition.
This is my reply.
Yes. What is the matter about?
Here, my lord, I have challenged the order of the appellate authority under section 9 of the appeal West Bengal Acquisition of Homestead Land, Agriculture, Labor and Artisan Fisherman Act 1975. My lord, more than 16 years delay was condoned by the appellate authority
You are challenging that.
without,
Continuation.
without assigning any specific reason. And then, my lord, I prefer an appeal before the tribunal court. Tribunal court also observed that you need not condone such delay and regularize the appeal for hearing. Against that, my lord, I have come. Kindly take up the order passed by the appellate authority. The initially appeal was filed under section 54 of the Land Reforms Act. But the act says that appeal ought to have filed under section 9 of that is the West Bengal Homestead Acquisition Act. Lordship has got the act.
Yes, you had probably given a copy on the last occasion before some other bench.
Yes.
Because it's
yes.
in the file. Yes.
Grateful, Lordship.
Yes.
Then, my lord, kindly.
So 9 is settlement of disputes. If there is a dispute
Then
as to whether land has vested under this act, shall be referred to the collector whose decision shall be final.
The main order was passed under section 4. Petitioner before your
There's the acquisition under section 4.
Petitioner before your lordships. She is a poor lady. She is in possession of only 1 decimal of the homestead land. The act says, kindly take up the section 4, that says the 26th day of June 1975, if she is in possession, she can apply for getting benefit of this. Accordingly, she applied, and my lord, hearing was conducted, and final order was passed by the BLRO. Kindly take up the order passed by the BLRO. Lordship will get the state weight. Kindly take up page 50. Page 50 of my lord's.
No, where an occupier has been in possession of any land on such and such date, then if the land in his possession does not exceed such land, and if in possession exceeds such and such, so much of the land as does not exceed shall stand acquired.
But the government will acquire, and then government will hand over by way of patta in favor of me. And that was done, murdered by way of order. Kindly take up the order impugned, passed by the BLRO, that lordship will get page 50.
No, but if it is acquired, then compensation will be paid to you.
To the owner, they can claim.
Yes.
And that is the not main issue.
You are not the owner.
No, I am the poor
Occupier.
lady, occupier.
Achha.
I got the land only 1 decimal for the homestead purpose. Under section 4. So then the remedy is that the owners agree, they can file an appeal under section 9. My lord, kindly take up the page 50. Order passed by the BLLRO. Ordered, lordship got, my lord, order
Yes.
dated 25th July 2007.
Yes.
Should I place, my lord? See in the case record, peruse the matter, and it is found that the case record that the then BLLRO Kagdeep has sought for the instruction that from the SDLRO Kagdeep regarding the disposal of the matter, but till date no reply has been received by the BLRO Kagdeep. Further, it is highly transparent to seek such type of instruction from the higher authority expressly in the order sheet, while the Honorable LRTT has been directed the BLRO concerned to dispose of the matter, but as the BLRO has sought for instruction as evident from the case record, I find no other alternative but to wait for the instruction. But
both the parties are present at the file Hajra heard them at length. Appellant claimed that after purchasing the land in question, corrected record was done in their favor, but to tutorial that the name of Minoti Goswami, petitioner herein, wife of such and such, has been recorded measuring 1 decimal of the land out of 2 decimal. Also, got more. Next page. Next page.
The petitioner, the applicants there were the owners or third parties.
Applicant is the possessor.
We are the owner.
They are the owners.
Or the owner.
You are the applicant before the BLL.
Yes.
No.
No.
Third party.
I am the applicant. I am in possession.
No, you are in possession. The
I-
applicant before the BLL, the applicant is referred to. The applicant's claim is that after purchase of the land, correct recording was done in their favor. Therefore, they were the applicants. They had purchased the land.
Yes.
They purchase, their name are recorded. Then
We have
I
purchased 2 decimals of land out of.
Yes, understood. You had.
I claim for 1 decimal.
Let him complete. Yes.
Because I am one sentence. Because kindly see the input against he has come.
We'll see everything. You take your seat.
No.
Yes.
The next page, Lordship will get second paragraph. It appears from the
Case record.
That the homestead, being case number 36, was started in the name of Vijay Krishna Goswami upon the prayer filed by the Goswami, and the said prayer was rejected. My husband's prayer was rejected with observation that his wife may be eligible for, may be filed in the separate petition. Thus, the case was disposed of. And earlier, my husband prayed, that was rejected. I was directed to file an application. Then Lordship kindly take the next page. Page 52, very important. From the reply given by the SDRO Kagdip, office memo number such and such, it is found that no instructions have been given to dispose of the matter. The Honorable LRTT, now on the scrutiny of the record and available papers on the perusal of the said matter regarding and favor of the opposite party has been under the West Bengal, that is the Act, West Bengal Acquisition and Homestead Fishermen Act, Labor Artisan Fishermen Act 1975. The applicant may therefore prefer an appeal before the appropriate authority to serve the relief, and BLO is appellate authority under the said Act. So D Act, the Honorable Court is advised to prefer under Section 9 of the West Bengal Act, Homestead Agriculture Act, before the appellate authority, such and such. So, I was given relief and they were given liberty to prefer an appeal under Section 9.
Yes.
This is the order passed in 2007. In spite of that, they prefer a tribunal application before the tribunal court, alleging that Bureau has not disposed of the case in terms of the earlier order direction given by the tribunal court. So, they filed an application for contempt. During the pendency of that contempt application, a status report was submitted by the Bureau before the court, which shows that that matter is already disposed of, and there was direction for filing appeal. So, tribunal court was pleased to dismiss the contempt application, that this contempt will not lie. That was already disposed of. Challenging that order, dismissal order of the contempt petition, they prefer an appeal before this Honorable High Court. Kindly take up page 54.
Yes.
The Honorable High Court, since that was finally disposed of, writ application was 14th July 2023. Lordship got,
Got.
the entire Their lordships were pleased to writ petition is directed against the order dated such and such, passed by the West Bengal Land Reforms Tenancy Tribunal, disposing the application for contempt on the ground of compliance of the order.
This was dismissed because
That was dismissed.
justified because it has already been disposed. Yes.
My lord, thereafter, my lord, all of a sudden we were received the memo of appeal filed by my learned friend, page 58.
54 is applicable. Section 54?
54 is not applicable. Section 9 is applicable. In my written objection, I specific took that point. This
54 appeal is under that act.
That the Land Reforms Act 54 appeal will lie. So, my lord, this basic thing is that they have preferred an appeal under section 54. The lordship will get a very important thing is the order dated 4th May 2007 and the order dated 25th July 2007 was subject to challenge. And that was filed after long period. After
what was 4th May?
4th May 2000, lordship will get the cost title in the matter of lordship will got on 50.
No, 25th July order you have placed before us. 4th
25th.
May, what order was passed?
That was the earlier order where direction was given to the SDL or you sent the reports, etc. Joint order was, this final order was challenged.
So by then what happened? This appeal was
Then page lordship will get
64 is the section 5 application.
section 5 with section 14, and lordship will kindly take up the order passed by the appellate authority.
Now, what was the ground of the delay? What was the delay?
Nothing.
Now, what is the period of delay?
More than 16 years.
Oh yes, 2007.
Yes. Now, after dismissal of the writ petition by the Honorable High Court, this appeal was preferred. Specifically, my lord, we took objection page 67, etc. Objection was written, objection was filed. Then, my lord, they allowed the authority allowed the petitioner to amend the correct the mistake.
They had filed a title suit.
Title suit was a separate issue, and that was, my lord, dismissed before the district. While
What was the issue in the title suit?
Title suit, my lord, they claiming that we are disturbing the possession, etc.
So, but they have pleaded section 14 of Limitation Act.
Yes.
Title suit is on a different footing.
Different footing. Kindly take up in the order sheet. Kindly take up page impugned order. Lordship will kindly page 78.
78, yes.
Order dated 25th July 2024. In the order, this is.
You are with him.
Yes.
Yes.
This is a reference case under section 9. In earlier order,
state has been served notice. Yeah.
Yes.
Oh, you're. Let us hear. You don't have much of a role to play, but you should have served on the state also, the opposition and the reply.
Yes.
If you have extra copies, please do.
We shall.
Yes, anyway, let us hear. Continue here. Yes.
Copy. I shall.
Matter is taken up as fixed. This is the under reference case under section 9 of the West Bengal.
It is treated to be section 9. Under section 9.
But they allowed them to correct. Earlier order lordship will get. That is order number 2.
But the authority is the same. The collector is the collector.
Same.
Then
we are not opposing on that. Yes. Correction may be allowed. But 16-year delay without assigning any reason, entire orders it will say.
Where do we get the limitation period? Is there any limitation period under section 9?
No. Limitation period is nothing. That should be within 30 days. Or 60 days or 90 days. But 16 year.
No, 3 years at best because Article 137. If no provision is there.
That can be done. But 16 years after dismissing this writ application by the Honorable High Court, now they prefer this appeal. Kindly take up the order. In the impugned order, lordship.
No, writ petition was against the tribunal's order.
That contempt application which was dismissed by the tribunal court, that was subject matter of challenge.
Yes, not this.
Not this issue.
This was never challenged previously.
That was never challenged.
They filed a contempt. In the contempt, they said that your order has been violated.
Complied with, so contempt will not lie. This matter in the order itself, DLRO said that you can prefer an appeal under Section 9, and then when the final order was passed, but that was they did not choose to do so, and after lapse dismissal of this application, this thing was filed.
In the order itself, it was stated that they're given liberty to
Yes,
file section.
yes. I have placed that order.
Yes, you please that.
The matter kindly take up the order.
Page 78, last paragraph.
Page 78, last paragraph. Tracing back the
Before that, the case is given.
Yes. It is found that on record that the instant appellant has initially moved before the Honorable West Bengal Land Reforms Tenancy Tribunal inaction on the part of the concerned BLRO in disposing the petition under in the Act 1975 by OA number such and such. On 19 December 2006, the tribunal directed the Bureau Kagdeep to dispose of the same within this specific period. Despite of such direction, the appellant herein had to move before the tribunal against by filing the OA such and such
Limitation
for
Act.
almost self-same cause. The Honorable Tribunal directed the aforesaid Bureau to dispose of the matter. Thereafter, MA means was a contempt application. MA such and such was filed in connection with OA case number such and such arising under section 15 of the West Bengal 15. Under section 15 is the contempt procedure laid down in the Tribunal Act. Tenancy Tribunal Act 1977. The concerned bureau has submitted a report compliance to disposing of the miscases section with the certain observation, and the application under contempt of the Court Act was finally disposed of the Honorable Tribunal on 11th November 2008, challenging the disposal WPLRT 38 of 2009 was preferred before the Honorable High Court, Calcutta, and finally on 14th July 2023, the Honorable High Court, Calcutta, while disposing of the aforesaid WPLRT with can number such and such, can number 2, passed the order observing inter alia therein. In fact, there is an order dated such and passed by the concerned BLO disposing the miscase number such and such. There may or may not be a justified grievance of the petitioner with regard to the order dated such and such passed by the concerned BLO. Such grievances are to be ventilated in accordance with the law before the appropriate forum. Considering the observation of the Honorable High Court, in my opinion, the instant reference case should be admitted, but this is the cause. But that was now can we take up the challenging the same? We prefer an appeal, page 82, order of the Tribunal Court. Order of the Tribunal Court, page 82. Order dated 18th November 2024. Lordship got my letter?
Yes.
Learned counsel by the appellant and learned government representative is present. Learned counsel by the appellant filed affidavit service, let the same capital record. Muhammad such and such, counsel appear on behalf of the private respondent 5 to 9 and 11 to 14 by filing work. Let the same capital hard all the side. Considering the private respondent of this way filed under section 9 of the West Bengal acquisition of homestead agriculture artisan fisherman act 1972 before the collector South 25, which is still pending. The appellant of the instant way has challenged the order dated and section passed by collector district South 25 under section 9 of the West Bengal Home Agriculture and in respect of the LR appeal case number such in which an application under section 9 of the Limitation Act was allowed by the collector, though there is no provisions of the engrafted in section 9 of the Act and for condonation of delay, which is not required at all. So, my lord, allow this. This is the subject matter challenge. 15 years, my lord, this is enough to enough. Even the suit, my lord, lordship, I should not suit dismissed. After 16 years, they can.
Let us see.
Next line, my lord, of that page 82. Be that as it may, for speedy disposal of this matter, we hereby direct the collector, that is district land and landowner South to conclude the proceeding pending before him in accordance with law as expeditious as possible, paper within a period of silence. There is no error in the order.
16 years after.
That is,
Since section 9 contains no limitation period.
no, since there is no nothing.
137 will be applicable and application is needed for the
When
dispute
there
to be
is,
referred.
when there is nothing, that is 137.
Residual
But,
clause.
my lord, but
And
my
no
lord,
explanation at all.
In this respect, my lord, actually there is no limitation period. That's why, my lord, the
That is what will decide, because if there is no limitation period, we have to read that in, because limitation period for residuary applications under the Limitation Act will apply. 137 is the limitation period. You yourself subjected to Limitation Act. You yourself subjected yourself to Limitation Act by filing a Section 5 application. Why did you file that? It was your Section 5.
before the appellate authority.
That was what was allowed. So why did you file Section 5 if Limitation Act is not applicable?
Inter file is not with me, that's why.
না না অ্যারেস্ট করেছি তোমার
কোথায়?
Interfile is not with you.
No, no,
The
not
appeal is this writ petition is arising from a Section 5 rejection. Section 5 is annexed to this application. You have used an opposition.
Yes, yes.
File is not
yes,
with you.
Yes, I rely upon that opposition, my lord.
So what is your argument on this? Your argument is that whatever the tribunal said, Section 9, there is no limitation. Therefore, you can file. You can come up at any point of time and file it.
Yes, my lord. This is my argument, my lord, that that should be allowed and that is allowed. And that's why, my lord, the tribunal. That's why the
137 governor.
That's why the landed tribunal directed to speedy disposal of that appeal.
Will
On
be
merit.
will be even speedier.
To
No, Section 5 should have been dismissed. Not after 16 years.
No,
Come
no,
on,
no.
there is a limit to everything.
No, my lord, since there is no specific provision with regard to limitation.
Read 137 into this. Because an application is necessary. You cannot just verbally go to the collector and say that I challenge. A dispute, the language is a dispute has to be referred. To prefer a reference, you have to make an application. It's not a provision of appeal, neither a suit. So 137 is the application, the provision which applies.
One WP was filed before this honorable court and that was pending. And ultimately that was disposed of, my lord. That is, I have annexed.
That was in respect of a contempt application. You filed a contempt application saying that BLLRO is not disposing it of.
That issue must that is the
You have never challenged it,
continuous,
never preferred any challenge before that.
continuous traveling. That is there.
No, no.
My lord, that's why, my lord, it cannot be kindly see. My lord,
What?
I have annexed with my my lord, opposition. My lord, may I place it?
What provision?
My lord, kindly see, my lord, at page number. My lord, apart from that, my lord, one thing, Lord, that patta has been, I have purchased in 1966. But that patta has been granted out of my 2 decimals. That patta has been granted 1 decimal without giving any notice beyond my knowledge. I am not in a position to.
You cannot reopen after 16 years. There is a limit to it.
Filed a title suit. I filed the title suit in the written statement. For the first time, I have come to know that a patta has been, that disclosed that patta has been issued in the title suit. Not before that, my lord. I could not, it was not within my knowledge. That is in 66, I have purchased the land.
Cannot enter into the merits.
And also, I am in possession. It is not, her husband filed a application for homestead patta, but it was not allowed since he was in service. Since he was in service.
1 minute, let us hear them first. Yes. You have completed? Yes, yes, please continue. Yes. Continue.
Yes, sir. Well, anyhow, to grab the land,
yes,
that a precious land, 2 decimals I have purchased in 1966. To grab the land by hook or crook, initially the husband of the petitioner made application. Since he is in government service, he failed. That's why, my lord, in the second attempt, and to grab the land, they have procured that patta. Beyond my knowledge, it is within his knowledge, her knowledge, and his knowledge that I am the owner of the land. No notice, nothing of the sort beyond my behind my back. That patta has been issued. We are not aware of in title suit at the time of filing the written statement. I have stated, my lord, at the filing of written statement for the first time they have disclosed that one patta has been issued. That is, I have stated in page number 6, my lord. That is, I have stated in page number 6, my lord. On
Wait. Please leave the court. Please leave the court. Please leave the court. Thank you so much. Yes, please continue.
I have stated in my affidavit in opposition, my lord, paragraph page number 5.
Yes, page number 5.
That the deponent states that the sum of the vendors of the private respondent in collusion.
We cannot enter into the merits of the matter. How can we enter into the merits of the matter? You are stuck up at section 5 stage.
Only with regard to that limitation, your lordship, if that be so, but the merit goes, my lord, that for the first time I have come to know in the title suit, in his written statement in the title suit, that yes, I have got a patta, but surreptitiously beyond my back that has been procured since her husband failed being a government service holder.
You are the applicant. What surreptitiously? You are the applicant in the proceeding where the order was passed.
No, the patta has been procured surreptitiously.
Maybe patta has been
behind my
surrendered.
back.
That was on the merits. You had preferred an application before the
BLRO,
which was decided.
yes. But regarding limitation, my humble.
You were the applicant. Your application was rejected. So you must have known. Should have. You are the party who preferred the application.
But
you are the first person who would know that your application has been rejected.
But in course of the traveling of the litigation before several courts, tribunal, before the Honorable High Court, that's why the time has been killed in the meantime. That's why, my lord, the matter may be hard on merit. My humble prayer is that, without going into technical point, that taking with liberal view, the matter may be hard on merit. Whatever may be there. That is my humble prayer. The Honorable Court is with humble power to condone the same with liberal view in respect of technical point. That the matter should be hard on merit. What is there?
Sorry.
No, kindly consider do that, my lord.
Affidavit in opposition and affidavit in reply. Affidavit in opposition and affidavit in reply filed respectively by the private respondents and the writ petitioner be kept on record. First of next para, the matter arises out of an order of the Land Reforms and Tenancy Tribunal, whereby the tribunal affirmed an order of the appellate authority, affirmed an order of the collector under section 9 of the West Bengal acquisition of homestead land for agricultural laborers, artisans, ARTISANS, and Fishermen Act, 1975, bracket is hereinafter referred to as the 1975 Act.
One thing I am
Learned counsel for the petitioner contents.
One thing I am praying, Lord. Practically in this matter, Soini Bhattacharya Chakraborty was engaged.
You should be ashamed of yourself.
But
should be ashamed of yourself.
But this was before the Honorable Justice Bosak. Now this has been shifted to this court. That's why I am.
প্রথম লাইনে প্যারাগ্রাফ একটা যেটা বললাম তার আগে
Kindly
after the hearing is concluded and the court is about to pass judgment, learned counsel for the respondent, to whom it was made abundantly clear that the writ petition is going to be allowed, seeks to raise an objection to this court taking up the matter on the purported ground that a relative of one of us within bracket Bhattacharya, J, bracket closed, had appeared at one stage in a different matter between the same parties.
I'm taking back.
Next para, however, we strongly deprecate such unsportsmanlike and unfair attitude of the learned advocate for the private respondents,
Sorry, I'm turning
comma,
back.
which would be beneath the dignity of any counsel to take. Full stop. We say so because after having come to know clearly that the court was going to pass an order against his client, comma, the learned advocate cites the appearance of the relative of one of us within bracket Amar Nam, right close, comma, that too in a completely different matter having no connection with the present writ petition. Full stop. Despite such previous matter being between the same parties, comma, there is no nexus between the said matter and the present one. Full stop. Moreover, comma, it is absurd that no objection was taken at the outset, but while passing the final order, comma, seeing that his client is going to lose the matter, comma, learned counsel takes such an objection. Full stop. Next para. To us, comma, it is shameful for a counsel to take such plea at such a stage, comma, since we are a part of the same system, that is the bar and the bench work in tandem, and an act beneath the dignity of an advocate hits the court more than the concerned counsel. সব নেক্সট প্যারা, তারপর যেখানে শুরু করেছেন
One thing I'm submitting in this juncture.
কোথায় ছাড়লাম? Contents that under section 9 of the 1975 Act, comma, if there is any dispute on the question as to whether a land has vested in an occupier under the provisions of section 4 of the said Act, comma, the matter shall be referred to the collector, sub jagah C capital, comma, whose decision thereon shall be final. Full stop. Next para. Section 4 of the said Act provides that where an occupier has been in possession of any land on the 26th day of June, comma, 1975, comma, then, comma, if the land in his possession does not exceed 0.0334 hectare, comma, such land, comma, and if the land in his possession exceeds 0.0334 hectare, comma, so much of such land as does not exceed 0.0334 hectare, comma, shall stand acquired by the state government and shall thereupon stand transferred to and vest absolutely in favor of such occupier. Full stop. Next para. The writ petitioner was declared to be such occupier by an order dated July 25, 2007 by the concerned BL and LRO. Full stop. Next para. The private respondent number 6, comma, on the allegation that the dispute had not been disposed of by the BL LRO, comma, thereby a contempt of a previous direction of the Land Reforms and Tenancy Tribunal having been committed, comma, had approached the tribunal alleging contempt. Full stop. Next para. The learned tribunal turned down the same in view, taking note of the fact that the proceeding initiated, comma, bearing miss case number 62 of 2003 had already been disposed of, and as such no contempt lay. Full stop. Next para. The writ petitioner, the private respondent number 6, preferred a writ petition against such order of the tribunal, which was also turned down by a coordinate bench of this court by an order dated July 14, 2023, passed in WP LRT 38 of 2009. Full stop. Next para. While dismissing the said writ petition, comma, the division bench observed, comma, inter alia, that the BL and LRO acting in terms of the order dated August 7, 2010 and passing a final order, comma, it cannot be said that the BL LRO acted in contemptuous violation of such order, comma, simply on the ground that there are grievances with regard to the order dated May 4, 2007 of the concerned BL and LRO. In such circumstances, comma, the court observed that the writ petition should be dismissed. Full stop. The writ court further observed that the order dated May 4, 2007 passed by the concerned BLLRO disposing of miscellaneous case number 62 of 2007 may or may not be justifiable, and the writ petitioner might have grievances against the same, which are to be ventilated, double inverted, in accordance with law before an appropriate forum, double inverted close, full stop. Next para, learned counsel for the petitioner, writ petitioner before us submits that merely by virtue of such observation, comma, no right was created to prefer an appeal in favor of the private respondent. Full stop. Next para, citing the pendency of the said writ petition and another unconnected civil suit, comma, the private respondent preferred a challenge under section 9 of the 1970 Act 75 Act before the collector. Full stop. Next para, although the said challenge was initially captioned as one under section 54 of the West Bengal Land Reforms Act 1955, comma, subsequently the same was amended and labeled LABELLED as a challenge under section 9 of the 1975 Act. Full stop. Next para. Learned counsel submits that although section 9 does not contemplate any limitation period, comma, the residuary provision in the Limitation Act should be applicable, and as such, comma, the challenge having been preferred after an inordinate period of 16 years from the date of the impugned order, comma, ought to have been turned down at the outset. Full stop. However, comma, the collector allowed the condoned the delay by observing that the case should be admitted for adjudication of the justifiableness of the grievances of the appellants on merit, as it is a law settled that technicalities of limitation alone cannot bring the process of adjudication to an end. Full stop. Next para. The tribunal affirmed the said order by going one step further, comma, observing that since no provision of limitation was engrafted in section 9 of the 1975 Act, comma, there was no scope for condonation of delay, which was not required at all. Full stop. Next para. Learned counsel appearing for the private respondent opposes the writ petition and submits that in view of a strong case on merits having been made out, comma, the learned tribunal was justified in affirming the order of the collector entertaining the challenge under section 9 of the 1975 Act. Full stop. It is further submitted that since section 9 does not contain any limitation period, comma, the challenge under section 9 could not be said to have been time barred. Full stop. Next para. Upon a careful consideration of the submissions of the parties, comma, we are unable to accept the contention of the private respondent. Full stop. Next para. It is well settled that even if no specific period of limitation is stipulated, comma, a party cannot be permitted to take out a challenge under any statutory provision to any order passed under the said statute after an inordinate period of time, comma, since valuable rights accrue in favor of the party enjoying the fruits of such impugned order in between. Full stop. Such rights, there has to be a finality to litigation and, comma, as such, comma, an inordinate delay of 16 years in preferring the present challenge ought to have been construed to be a sufficient ground for dismissing the challenge under section 9 of the 1975 Act, comma, if not otherwise, comma, on the ground of equity, comma, since the private respondent did not come with clean hands in preferring the challenge after long 16 years. Full stop. Next para. Even otherwise, comma, we are to consider as to what is the nature of a challenge under Section 9 of the 1975 Act? Full stop. The language in which the said provision is couched is that if there is any dispute on the question as to whether a land has vested in an occupier under the provisions of Section 4 of the said Act, comma, the matter shall be, তারপর double inverted মধ্যে, referred, double inverted clause, to the collector. Full stop. Next para. A reference cannot be verbal, comma, since the grounds of challenge as well as the nature of the order are to be disclosed while referring the matter to the collector. Full stop. Next para. As such, comma, since neither a suit nor an appeal lies before the collector, comma, since both are creatures of statute, comma, it has to be construed that the reference to the collector under Section 9 has to be by way of an application. Full stop. Next para. The residuary provision in the schedule of the Limitation Act 1963, that is Article 137 thereof, provides the limitation period for any other application for which no period of limitation is provided elsewhere in the said Act. Full stop. Such limitation period is stipulated therein as 3 years from when the right to apply accrues. Full stop. Next para. It is to be noted that Section 29 of the Limitation Act, comma, in subsection 2, comma, specifically provides that where any special or local law prescribes for any suit, comma, appeal or application a period of limitation different from the period prescribed by the schedule S capital of the Limitation Act, comma, the provisions of Section 3 shall apply as if such period were the period prescribed by the schedule, and for the purpose of determining any period of limitation prescribed for any suit, comma, appeal or application by any special or local law, comma, the provisions contained in sections 4 to 24 within bracket inclusive bracket close shall apply only insofar as, comma, and to the extent to which, comma, they are not expressly excluded by such special or local law. Full stop. Thus, comma, on a plain reading of Section 29 within bracket 2 of the Limitation Act, comma, if no specific limitation period is prescribed in a statute, comma, by necessary implication, comma, the provision of Section 3 shall apply as if such period were the period prescribed by the schedule of the Limitation Act. Full stop. Next para. Since no specific period of limitation for taking out a reference under Section 9 of the 1975 Act has been prescribed in the statute, comma, it shall be deemed, comma, on a composite reading of sections 29 within bracket 2 and Article 137 of the Limitation Act, comma, that the limitation for such application stroke reference will be 3 years from the date when the right to apply accrues. Full stop. Since the order which has been challenged before the tribunal, before the collector under Section 9 was passed by the BL and LRO on July 25, 2007, comma, the date of accrual of the right to apply arose on the self-same date, comma, since the private respondents, comma, who have subsequently preferred the challenge under Section 9, comma, were themselves the applicants therein, and the order was passed in their presence. Full stop. Thus, comma, the limitation period for preferring a challenge under Section 9, comma, under the residuary clause of Article 137 of the Limitation Act, comma, expired 3 years after July 25, 2007, that is on or about July 24, 2010. Full stop. Next para. The challenge under Section 9 was filed after an inordinate delay of 16 years thereafter, comma, thereby being hopelessly barred by limitation. Full stop. In the application, even the private respondents, comma, by filing an application under Section 5 read with Section 14 of the Limitation Act, comma, submitted to the jurisdiction of the Limitation Act and admitted that the Limitation Act is applicable. Full stop. Next para. The grounds for condonation of delay cited by the private respondent in the said condonation application was primarily that the private respondent was engaged in litigation otherwise. Full stop. One such litigation was cited to be the challenge before the Land Reforms and Tenancy Tribunal and the subsequent writ petition. Full stop. However, comma, the said challenge was on a completely different footing and not an application under Section 9 of the 1975 Act or a challenge to the order dated July 25, 2007, comma, whereby the BL and LRO categorically held that on scrutiny of the records of rights and available papers and on perusal of the matter, comma, the recording in favor of the present writ petitioner was upheld. Full stop. In fact, comma, the application filed before the Land Reforms and Tenancy Tribunal was on an allegation of alleged contempt on the perception that the BL and LRO had not disposed of the matter, comma, contrary to the directions of the tribunal. Full stop. The tribunal turned down such plea on the ground that the matter had already been disposed of, and the writ court affirmed the said order. Full stop. Hence, comma, the said application for contempt cannot be equated with a challenge to the substantive order dated July 25, 2007. Full stop. Next para. The other litigation cited by the private respondent in the condonation application was a title suit between the parties, which, comma, however, comma, was on an entirely different footing, comma, not being a challenge to the order dated July 25, 2007 in any manner whatsoever. Full stop. Next para. Thus, comma, the pendency of the other litigations are not germane and do not attract the provision of Section 14 of the Limitation Act as sought to be argued by the private respondent herein. Full stop. Next para. That apart, comma, in the order impugned in the order of the BLLRO dated July 25, 2007 itself, comma, the said authority categorically recorded that the applicant therein, that is the present private respondents, may prefer an appeal before the appropriate authority under Section 9 of the 1975 Act, thus making it abundantly clear as to what provision was to be resorted to by the private respondent. Full stop. However, comma, thus, hence, comma, the private respondent cannot feign ignorance on the available remedy in that regard. Full stop. Next para. Hence, comma, on a composite consideration of the above circumstances, comma, we are of the opinion that the learned tribunal acted completely without jurisdiction in coming to the conclusion that the applications of the Limitation Act are not attracted, comma, since Section 9 of the 1975 Act does not specifically stipulate any limitation. Full stop. Next para. Insofar as the order of the collector under Section 9 is concerned, comma, the same merely deals with the condonation application in an absolutely cursory manner, comma, by observing that the limitation, the objection as to limitation was a mere technicality, comma, without considering the huge and inordinate delay of 16 years in preparing the challenge. Full stop. Next para. Instead of relegating the parties back to the first forum, comma, since we have discussed at length the grounds cited by the private respondent for the condonation application, and as we have turned down such grounds, comma, it was a palpable act of traveling dehors jurisdiction on the part of the Land Reforms and Tenancy Tribunal and the collector, comma, in passing the orders impugned herein. Full stop. In such view of the matter, comma, WP LRT 14 of 2025 is allowed on contest, comma, thereby setting aside the impugned order of the tribunal, impugned order of the West Bengal Land Reforms and Tenancy Tribunal, comma, second bench in case number OA2536/2024 bracket LRTT, as well as setting aside order number 3 dated July 25, 2024, passed by the collector, comma, collector under section 9 of the 1975 Act, and ADM and DL and LRO, comma, South 24 Parganas. Full stop.
In LR appeal number.
Pardon?
In LR appeal number.
In LR appeal number 981 of 2023. Full stop. There will be no rise to cost. Thank you.
Grateful, Lords.
Judgment. WB electrical judgment form नहीं करोगे. Next. Pass over. देखिए रेस्ट. Yes. Yes.
But
rules
I have prepared
yes
brief list of the relevant dates.
Thank you. Yes. ये माइंस এটা আমাদের কোর্টের গুড এটা কি
Briefly, my lord, encapsulating, my lord, I submitted before
Yes.
my lord.
Yes.
My lord, that this relates to an interplay between, my lord, the 2002 and the 2016, my lord, minor mineral rules.
Yes.
My lord, I submitted before my lord.
Yes.
My lord, that I have been granted a mining lease, my lord, in terms of, my lord, the section 4, my lord, of the 2002 minor mineral rules. My lord, it was, my lord, for a period of 5 years. My lord, the lease deed was executed. Clause 3 of the said lease deed, Lord, provided for a renewal clause. Lord, there would be a maximum of one renewal of like period at the option of the lessee. Lord, as a lessee, my lord, I opted for the renewal.
Yes.
Lord, the renewal application was not being considered. I came up before this honorable court seeking, my lord, the direction upon the competent authority to decide on my application. My lord, my writ petition was dismissed on 2 scores. Lord, one, that my application was incomplete in as much as the requisite fee of ₹500, my lord, is not, my lord, reflected from any document of my writ petition. My lord, the second ground was that in the meantime, 2016 West Bengal minor mineral rules 2016 have come into effect. My lord, Rule 61 thereof says that all pending applications for grant of mining lease, Lord, would now become ineffective.
To distinguish with renewal application.
Yes. Lord, that was, my lord, the stage, my lord, where, my lord, I had to stop because the business of the court did not.
And Rule 62(2) says anything done, any action taken is protected.
My lord. Lord, my lord, again, Lord, beseech your lordship, so kindly, my lord, have a look, my lord, at the...
Today we have.
I'm sorry.
Yes. Thanks to our officers, actually.
My lord.
Yes.
Lord, kindly, Lord, takes up that Rule 4 capital A.
2016 rules.
2002.
Yes.
My lord. Lord, my endeavor would be, Lord, to demonstrate before my lord that the 2002 rules, Lord, had a complete and exhaustive, my lord, definition with regard to the rights and obligations of the parties.
What was the name of the 2002 rules?
Lord, it was West Bengal Minor Mineral Rules 2002.
This is a different.
And the 2016 rule, my lord, it says concession. The word concession is incorporated.
Minor mineral rules, Don't know.
2016 rules, my lord, uses the word
16 rules is there, but 2002 rules is different. Prevention of illegal mining, some other rule.
Yes, yes.
Sorry, 2002 we don't have.
My lord, yes.
Our library doesn't have actually.
Kind.
This is a different rule.
My lord, kindly sees rule 4A.
Yes. Yes, 4A.
My lord, kindly sees grant of lease or quarry permit. The state government may from time to time by public notice invite application for grant of mining lease or quarry permit in a particular area, and then every such public notice shall be published through an advertisement also by affixing the office of the concerned DNL LRO so and so. Notwithstanding anything contained in sub-rule 1 and sub-rule 2, if an application is received before coming into force of this notification, publication of the public notice after coming into force of this notification, state government shall, subject to the fulfillment of conditions under rule 5 by the applicant, consider such application along with applications received in pursuant to the publication of public notice. Now, the mode was that, my lord, public notice would be given, my lord, applications would be received, and these applications, my lord, would ultimately, my lord, fructify into, my lord, grant of a mining lease.
Yes.
Now, my lord, kindly sees, my lord, sub-rule 5, 1. A mining lease shall be granted by the state government or an officer authorized by the state government in this behalf. And then 2, an application for mining lease shall be made in 6 copies in the form A, accompanied by a challan showing non-refundable deposit of rupees 500. So rupees 500 is prescribed in 5.2. Now, my lord, kindly sees, my lord, rule 8, sub-rule 2. If my application is incomplete or defective, then 8.2 is an application for grant or renewal of mining lease shall not be refused by the state government or the officer so authorized by it only on the ground.
This is rule
8, sub-rule 2. 8 says refusal of application for grant of a mining lease.
Yes.
I am reading sub-rule 2.
2 was substituted by 2000 in 2006. Footnote.
My lord, rule, yes, my lord.
So
mine is after this. My grant of
2 is not there. Then 2 won't be there because it says substituted by the amendment of 9/1/2006 with effect from 19/1/2006. So if it's your application was after 2006, then 2 won't be there.
But the substituted is now 8.2.
No.
Subject to being corrected.
Which was earlier as follows, and 8.2 is there. This is your copy.
My lord, yes.
Just see, Mr. Chaturvedi, earlier is given at the footnote. It's stated earlier is this.
Yes, my lord. Earlier, this was, my lord, 8. What is there in the footnote has now become
without that.
Without that.
So you are reading 8.2.
I am reading 8.2, which, my lord, after the footnote gets omitted, has been substituted by 8.2 with effect from, my lord, 9/1/2006. My lord, this is now, my lord, we are, my lord, beyond 2006. Beyond 2006, my lord, is what is, my lord, printed, not the footnote. The subject to being corrected.
No. The substituted is the one which is given in the main text.
Yes, I'm saying so.
2 is not there in the main text. The main text is 8. Refusal of application for grant of a mining lease. 1. The state government, while disposing of the applications, may hear the applicant and give reasons in brief in making the choice among the applicants.
Yes.
And in the footnote, it stated substituted by IBID. That is the notification dated such and such with effect from such and such, which was earlier as follows. That means the current 8 without 2 is the substituted rule, which was earlier containing 2. The language is, because the main text is the current version. It is always the main text which is the correct version.
Yes, my lord. The main text, my lord, my main text, my lord, is showing 8.2. Am I?
Just the other way around in this. Here, the main text is showing 8 without 2.
I'm sorry, my lord.
And footnote says, আপনার আমারটা একই জিনিস, একই.
Lord, are we looking at the same provision?
We are not on the same page.
Lord, kindly, my lord, kindly look at it. Lord, with effect from 9th, left hand side bottom.
It's just the opposite here.
I'm so sorry, my lord.
It's just the opposite here. The common law house. Sir Chaturvedi, yours is common law house.
Lord, this will not get reflected in the decision which will not I shall cite before my lord.
Then we will go by that. Yes. But just see, tax and law, we don't know. Prior experience, common law house, I had experience while citing before a court. Provision was not. Mr. Shyaprachana Roy Chaudhary was on my other side. His common law house book did not contain a provision. And he was very angry, and I won the case on that basis. But Mr. Chaudhary, if it's recording a cited, we don't know the cited judgment is, I mean,
relying on which one?
Yes, whether the cited judgment relied on this version or that.
But, only one thing, Lord, this will not make much of a difference.
Anyway, what was there in 2?
Lord, 2 says that an application, my lord, which is incomplete, my lord, would not be, my lord, refused on such ground only, and that 30 days time would be given for me to rectify. This is an amendment, my lord, which has been brought to section 8 with effect from 9th of January 2000.
But this becomes very vital, Mr. Chaudhary. This should clinch your case. I mean, even without this, you have, otherwise you have a case. This should clinch your case.
But the Honorable Division Bench, my lord, precisely says this and relies on another decision. I shall come to that.
That is more risky. In the division bench, I mean, decides on another division bench, which relied on a particular version. We should, I think we should refer in our judgments which publisher we are relying on. Mr. Chaudhary,
earlier,
can you please just Google search this 2002 rules, if it's there by any chance?
My learned junior in
yes, we are addressing him directly. That's why.
Yes,
not bothering with him, Mr. Chaudhary, on these things.
My lord. So
let him do that in the meantime. So if
yes.
if 2 is still there, then
yes.
I mean, it was still there before 2016, then you'd have a better case.
My lord.
Because only on a technical ground, it could not have been refused.
My lord.
As opposed to an application.
My lord.
Very well.
Now, my lord, kindly, my lord, sees, my lord, rule 11. My lord, kindly sees period of lease. The period for which a mining lease may be granted shall not be more than 5 years. But if the state government considers, my lord, this is not relevant, shall not be for a period of more than 5 years. And then, my lord, kindly sees, my lord, rule 12, renewal of a mining lease. An application for renewal of a mining lease shall be made to the state government or to an officer duly authorized by the state government in this behalf in Form D at least 6 months before the date on which the lease is due to expire, but not before 9 months from such date of expiry.
As you said, 6 to 9.
So that, my lord, window of 3 months, my lord, is provided.
And you applied within that?
Yes. Now, my lord, kindly sees, my lord, sub-rule 2. No such renewal shall be granted.
This was actually copied in the clause 3.
My lord.
This provision was basically the gist of this was there.
Yes. But kindly now sees, my lord, 3. Every application for renewal of mining lease shall be accompanied by a non-refundable fee of 500. So new application, I showed to my lord. Renewal clause again, my lord, has a provision for a fee. Now, my lord, kindly sees, my lord, 6, sub-rule 6.
Yes.
If an application for renewal of a mining lease submitted to the receiving authority within the time as referred to in sub-rule 1 is not disposed of before the date of expiry of lease, the period of that lease shall be deemed to have been extended for a further period of 6 months, or period extending with the date of receipt of orders of the state government thereon, whichever is earlier. Now, my lord, my mining lease was to expire on the 26th of March 2017.
Uh, 20?
But 26th March 2017.
Right.
Lord, may I, my lord, only?
Yes.
But this, my lord, contains 8.2. This is a gadget notification I am looking at.
Yes, that is what we are looking.
My lord. I am little hesitant, my lord, to hand over this to my lord, but
No, need not. You are saying that is sufficient. Then we'll read it into.
my lord. This is a gadget notification, my lord, published on the 8th of November 2002.
No. That contains 8.2. If
Lord,
that be so,
no, the amendment which is contained in this, the notification is 8th November 2002. And Lord, the amendment is Lord
indicates the amendment also.
Yes, yes.
All right. And rupees 500, you had not produced any challan before the
Before the learned single judge.
Single judge you had not produced.
I did not, but I indicated to my lord, that in the pleading that I have made an application in accordance with law, and law is that it should be accompanied with 500. So by necessary implication, I say that my application was complete in all respect, which was received by the authority. The respondents appeared in the matter, did not take up an objection with regard to the application being incomplete. Any payment, there is a payer and the payee. The payer says, that I have paid. The payee does not say that I have not received. The court cannot make out a third case that since you do not produce a document, hence.
And that too at the outset.
My lord.
No, if it is so directed.
No direction for ability.
No, the court recorded that.
Now, my lord, kindly sees, my lord, Rule 15.
Yes.
Lord, this is a provision which provides for, my lord, execution of a lease deed. So, my lord, there is a statutory flavor, my lord, to the document, my lord, which is being executed by, my lord, state on behalf of the state. Now, my lord, Article 299, 300 of the Constitution. In the name of the governor, a lease deed is being executed. When an order has been made for grant of a mining lease, the deed of lease shall be executed within 6 months from the date of the order granting the lease. Then an officer can be maybe authorized to execute the deed on behalf of the state.
That is the logic of 12(6).
My lord.
That's 6 months.
My lord.
Disputed regarding this. Issuance of lease, there is no dispute at all.
No.
There should be no dispute in the main matter also.
And then, my lord, kindly sees Rule 24. This is the last rule, my lord, which I intend, my lord, to cite, to show, my lord, before I go into the merits of the case. Lord, Rule 24, standard form of lease. So, rules prescribe also for a standard form of lease.
Why are you,
yes, Lord, why, my lord, I not show this? Is, Lord, that this, my lord, is a complete code, my lord, which is defining the rights, my lord, of and obligations of the parties in right from grant until the execution of deed. All, my lord, has got, my lord, a statutory flavor. In terms whereof, it is provided that contractual rights and obligations will bind the parties for the period defined, along with a renewal clause which would be for a period, life period of only one tenure. Now, my lord, kindly sees, my lord, my application. My lord, kindly sees page 87.
Your renewal application was, they sat tight over the matter, that's why you had.
Yes, and this is that application.
Sorry, this is page?
87.
Yes, 87.
Now, my lord, kindly, my lord, permit me to read, my lord, the second paragraph of my application, starting with the words, a sum of rupees 500. My lord has very kindly got it, my lord. It starts with, sir, IV request.
No, this is some other page in.
I'm sorry.
No,
May I?
of your application.
I come to the paper book. I'm sorry. I should have not referred to the paper book. Lord, kindly sees page 87. This is Lord the challan.
This is the challan, yes. You placed on the last page, 29th of August 2016.
Yes. And now, Lord, kindly comes to Lord page 17, 17.
Yes.
Lord, kindly sees, Lord, the second paragraph of my application, starting with the words,
a sum of rupees.
Sum of rupees 500. Number 87 is the challan which is referred to in my application at page 17. But this page 17 was not a part of the writ petition. Apart from the fact that I have said in my writ petition that I have made the application in accordance with law.
Have you filed any application in the nature of order for 2027?
But I have.
So this challan could not have been a part of the paper book.
No, leave was granted to me by the coordinate bench. Lord, I filed it in terms of the leave granted by the honorable.
Leave was granted to include all documents which you want to rely on. Or?
Leave was granted
specifically for challan.
Only for the challan.
Oh, achha.
Only for the challan, and no other document, my lord, was included. So, my lord, this is, my lord, my application. Right. My lord, I indicated to my lord, my averment at page 7, paragraph 6.
Yes.
But the first subparagraph to paragraph 6, starting with the words that your petitioner made an application dated 31st August 2016 for renewal of the same in accordance with law.
Yes.
Now, my lord, 2016 rules, my lord, they came into effect with effect from the 29th July 2016. Lord, my application is 31st August 2016.
Not 30th July?
No. 30th July, 30th August is the challan and 31st August is the application.
30th August is the challan.
30th.
Let us just check. 29th July was the challan.
August.
29th August was the challan.
Yes, 29th August, my lord, is the challan.
And 30th August would be the application.
30th August is the application.
Yes.
And this is, my lord, my lease was subsisting.
31st August is the application. 31st August is the application.
Page 17.
Page 18. Date of the was. Page 18 is the date, my lord. 31st
yes, 31st August. Right.
The application.
Right. Thank you. Thank you. Very good.
Now, my lord, the learned single judge, my lord, dismissed my application on the two scores, my lord, that I submitted before.
500 and 2016 has.
And 61. 500 and Rule 61. Now, my lord, kindly takes up, my lord, Rule 61 of the 2016 West Bengal Minor Mineral Concession Rules. Lord, kindly sees the declaration of ineligibility of the pending minor mineral applications for mining lease, including applications for reclassification. This is not relevant. So, my lord, there was a conscious omission as regards to the rights of the persons who are already enjoying the benefit of grant of lease and the rights reserved therein in terms of clause 3 of the lease deed. Well, the application for mining lease, Lord, is not added up with any application for renewal of the mining lease. Now, my lord, a little historical background to my lord, the 2000 rules is.
So 2016 rules came to force from 29th of July.
29th July 2016.
All right.
Now, my lord, a little historical background, my lord, to the paradigm shift of the state government in grant of mining lease from 2002. My lord, in 2011, what was done was these rules which I cited before your lordships, the 2002 rules, rule 4 until rule 16 was omitted. That means the entire process of grant of mining lease by notice, seeking application and the DLRO deciding on the applications, this was done away with. In the place of that, what was done was that that mining lease would be granted by auction. These rules, the virus of these rules fell for consideration before this honorable court. But the honorable division bench said that, and the court was determining an application for renewal of mining lease. There, the virus was also challenged. But the virus, the rules were declared ultra virus, and the court went a step ahead to say that even if we hold the rules to be intra virus, the contractual rights of the lessee stands preserved in view of clause 3, which provides for a right to opt for extension or renewal of mining lease, and the option was vested with the lessee. If such an option is exercised, then the contractual rights would prevail. The amendment would not extinguish such rights. I come directly to that decision. This would in my humble understanding clinch the issue. This is reported in 2014 SCC Online Calcutta 13995. कॉपी रख लेता हूँ. Lord, kindly comes to the second page.
Yes.
Lord, kindly skip over the first 5 lines. Lord, kindly start with the line starting on the right hand side with those leases were granted for a fixed period. My lord is very kindly.
Got it. Yeah.
Fixed period with a renewal clause giving option to the lessees to apply for renewal within a specified time before expiry of the leases. The petitioners applied for renewal of their leases in terms of renewal clause contained in their respective lease deeds. Their application for renewal were rejected by the concerned authority by referring to the amended provisions of West Bengal Minor Mineral Rules 2002, which was introduced in the year 2011, either during the continuance of the leases of the petitioners or pending consideration of the petitioner's application for renewal. Not a like situation. Then, Lord kindly comes to the third paragraph. Lord kindly skips over about Lord 7 lines from the top. Lord kindly sees the line starting with the words on the right hand side. Renewal of mining lease.
Yes.
Renewal of mining lease was prescribed under Rule 12. How much deposit is to be made by the applicant toward preliminary expenses and security deposit was dealt with in Rule 13 and 14, respectively. The period within which the lease is to be executed was mentioned in Rule 15 of the said rule. Lapsing of the lease was mentioned in Rule 16 thereof. There were relevant provisions of the Rules 2002 which governed the field of granting of lease and or renewal thereof when the mining leases were granted by government in favor of the petitioners. The amendment which was introduced in 2011 brought about a thorough change in the procedure for grant of mining lease in respect of the riverbed materials, excluding so and so.
This is unimportant.
By the said amendment, Rule 16A and 16B were introduced. Now, my lord, like nature, the existing right of a lessee to seek renewal, my lord, stood abolished because Rule 12 was also abolished.
Yes.
In my case also, by dint of the 2016 concession rules, there is no right of renewal. There is no right of renewal. And the learned single judge, Milord, has read the right of renewal to be a part and parcel of 61.
Yes.
Now, Milord, kindly comes, Milord, directly to paragraph 12, which would be about my lord, sir, very kindly got it.
Paragraph 12.
My lord.
Paragraph numbering is not there in.
Renewal of mining lease.
Achha.
The successful bidder shall.
Which page?
There is the page number.
The page 9.
Page 9.
On the top, my lord would find
12, yes.
Page 9.
Oh.
Lord kindly sees the third subparagraph of paragraph 12, starting with the words, in fact, the application for renewal of mining lease of all of the petitioners were all rejected by the concerned authority, referring to the aforesaid amended provision of West Bengal Mine and Mineral Rules 2002. The legality and propriety of such order of rejection of the petitioner's application for renewal is also under challenge in these writ petitions. Now, my lord, the relevant portion where my lord I place reliance is Lord kindly comes to page 19, 19.
Yes.
Lord, the fourth paragraph starting with the words, thus, if the legality of the amendment is considered.
Yes.
In the context of section 15 of 15(1)(a) and 15(3) of the Mines and Minerals Development and Regulation Act 1957 and Rule 20 of the West Bengal Mine and Mineral Rules, then I have no hesitation to hold that the rules were introduced by way of amendment are not only ultra vires of section 15 of the Act, but also these amended rules are ultra vires entries so and so of the Constitution of India. The rules were held to be ultra vires. Now, my lord kindly sees, my lord B, the
No, what is the amended rules of 2011?
2011.
2011.
That is a different.
Different.
2011 amendment to the 2002 rules.
The 2011 amendment, my lord, did not protect any right of renewal.
No.
My lord, the order impugned in the writ proceeding where, my lord, right of the lessees to seek renewal. And, my lord, the virus of the statute taking away, among other, the right of renewal was under challenge. But the court, my lord, held that the amendment is ultra virus. And then my lord said that even if it is held that the amendment is intra-virus, means that Rule 12 is now done away with.
Contract remains.
Then contract remains.
So,
This is, my lord.
So where do we find that?
My lord, kindly sees B. But
Same page 19 or
on page 19, my lord, the last paragraph with bold heading B, challenge with regard to validity of order of rejection of the petitioner's application for renewal. My lord, kindly, my lord, skip over and kindly sees the last two lines.
Yes.
Even assuming that the amended rules are valid, still then the decision for rejection of the petitioner's application for renewal taken by the competent authority cannot be supported. In this regard, I would like to mention here that first of all, since the amended rules were not given effect retrospectively and it was introduced with prospective operation, the right which was accrued in favor of the petitioners to have the lease renewed as per the terms of the lease deeds cannot be nullified by applying the amended provisions of the said rules. To clarify this position, I feel that the relevant clause of lease deeds is required to be taken note of. Then, my lord, the same clause 3, my lord, which is, my lord, a part of the lease deed which I indicated to my lord yesterday. My lord, I show it to my lord again if required. Now, my lord, kindly sees.
Oh, the provision in the contract is the only thing which will save you, Mr. Chaturvedi, because Rule 62 of 2016 rules clearly repeals the entire act apart from anything done, any action taken or any prosecution started under the said rules. Any action taken, if you read any action taken to include that agreement entered into between you and them in the first place, then that contractual right you can enforce.
Well, I am doing that.
Because because your application 61 does not apply for other reasons also. 61 applications which are pending, your application is admittedly after the date of the.
Again, 61 is only in respect of grant of mining
61, even if 61 was in respect.
I would be hit by 62.
Yeah,
I would
61 is utterly immaterial because of other reasons also. Your application was in any event after the coming into force of the 26 rules.
That's why, my lord,
these hit pending applications.
Yes, Lord, I say
that 61 need not have been referred to at all. If the court was actually bent upon this, 62(1) would be sufficient.
Yes.
So the contractual right is the only right you can.
Only that much.
61 is a superfluous reference.
Yes.
In the
because my application, my lord, was not pending.
Nor is it an application, the original application for lease mining lease, nor was your application prior to pending at the date.
My lord.
So 62(1) is what could have hit you.
My lord.
Unless we say that the contract itself is an action under 62 and borrowing the logic from this judgment that in any way it's a contractual right also now.
Which can be enforced.
Crystallized into the contract.
My lord. Now, my lord, kindly sees the next page. Lord, I am on page 20. But the last one paragraph starting with the words, the renewal clause on page 20, last but one paragraph.
Yes.
The renewal clause
makes
it clear that the lease is renewable at the option of the lessee. If a lessee is desirous of taking a renewed lease of the premises or any part thereof for the further term of 5 years, then he is required to apply for such renewal before the concerned authority prior to expiration of the term of lease by giving 6 calendar months previous notice in writing to the state government. After receiving such application from the lessee, the state government is required to consider the lessee's application for renewal in accordance with Rule 12 of the West Bengal Minor Mineral Rules 2002 and pass necessary order as it deems fit. The terms of the said lease deed also provide that government may refuse to renew the mining lease over whole or part of the area under the original lease for which the renewal is paid for. However, the government cannot refuse to renew the lease as a whole, save and except under any grounds as mentioned in Rule 12 of the said rules. Now, none of these grounds of refusal will not exist in my case. For the entire period of pendency, or even when I filed the writ petition, it was not, my lord, made the submission on behalf of the respondent.
No, it was premature to say that it was hit. Because your writ petition was only for non-consideration of your application.
Right. No, I say that the state government will not could have come up with an explanation that application, although the order is not
We are before
communication.
that stage. In fact, we are before that stage.
Yes.
Non-consideration, you moved a writ petition, court prejudged the issue and said that no, 2016 rules have come, so they need not consider because it's no longer, valid in the eye of law.
My lord.
So that was a prejudging also. That is also another ground you can take, that the court, instead of directing the government to decide it either way,
I'm coming to that.
prejudge the issue itself.
I'm coming to that. Now, my lord, kindly see page 21. But immediately after the quotation of the rules, the paragraph starting with the words, the said rules thus make it clear.
Yes.
Make it clear that renewal can be refused only when the performance of the lessee for the previous period is considered unsatisfactory by the government or by the officer so appointed in this behalf of the state government. However, prayer for renewal may also be refused under Rule 12 due to procedural lapses on the part of the applicant. Prayer for renewal of lease, in my view, cannot be rejected for procedural lapses if the procedural irregularities are rectified by the petitioner to bring his application for renewal in conformity with the provisions of the state rules.
That is on the 500 rupee.
That is Rule 8.2. That application will not be rejected on technical grounds. An opportunity would be granted. 30 days time would be granted. If 30 days time is also not availed of to cure the defect, then the application would be rejected.
Yes.
Number kindly sees the next paragraph. In view of such renewal clause provided in the lease deed itself, it cannot be held that no right was vested upon the lessee for renewal of the lease. Such right of renewal is vested with the lessee under the contract itself, which of course, no doubt could have been modified by the state government at its instance in terms of clause 12 for bringing the terms of the said lease in conformity with the amended rules. The terms of the contract which is provided in clause 12 thereof is relevant for present consideration, as the state government's right to modify the contract for bringing it in conformity with the amended rules was reserved. And neither in this case nor in my case, clause 12 has been taken recourse to by the state government, and the terms have not been modified. So I remain protected in terms of the lease deed executed in my favor, and more particular clause 3 thereof, which I seek to enforce. I make an application, and my application is not considered, come up before this honorable court. This honorable court prejudges the issue that Rule 62 would hit me and say that I have my application, it suffers from irregularity. I say that the domain of a decision lies with the authority competent under the rules, should have been left to it if I am hit by 62 or not. And insofar as the irregularity is concerned, that is curable. The rules themselves say, and it has been held in this.
But here, clause 3 says the mining lease shall be renewable for one period not exceeding such and such period.
Yes. And
the option of the lessee, but the proviso says, however, that the state government may refuse to renew a mining lease over the whole or part of the area covered by the original lease.
Yes.
For which renewal is paid for.
And
so that your option is curtailed by this proviso.
Yes.
They may just refuse.
Yes, subject to the conditions provided for in clause in the other clauses of clause 12. The conditions which are.
And if you come to page 58,
my lord.
Yes. Page 58.
Yes.
If you see the proviso to Rule 3.
Not yes. But this is not also there in 12 sub Rule 3.
This is almost a replica of that.
Yes, yes.
Yes. No, but it is different.
What kindly see is
sub-rule.
May I?
No.
You kindly see 2.
Yes.
No such renewal shall be granted for more than once for a period exceeding period of original lease, and the state government or the officer so authorized in this behalf may refuse, after giving reasons to be recorded in writing, to renew a mining lease over the whole or part of the area covered by original lease for which the renewal is applied for. So there has to be, when it calls for a reason.
Reason in writing is not provided in your contract because it's a contract which you fall back upon.
Yes.
Reason in writing is not there in your contract. That has been omitted. And the proviso to 12.1 is also not there. No such renewal shall be granted if the performance of the lessee is considered unsatisfactory or these grounds cannot be read into. They can just outright dismiss.
May I, my lord, kindly.
But then again, the next provision is also there. The state government on receipt of application for renewal shall consider it in accordance with Rule 12 of the said rules. Your clause says that. The last sentence of page 58. The state government on receipt of an application shall, that is again in terms of 12, and shall pass orders as it deems fit.
Now, this contract is in terms of Rule 12.
Yes, but this proviso is an aberration to the rest of the.
And this
12 requires a 12.2 requires a reasoned order in writing. This does not require.
And the division bench judgment which I showed, it said that without cogent reasons, my application for renewal cannot be refused.
And if you see the next clause, the next part of the of clause 3 of your contract, maybe it can be argued that it has to be read into it. That if the lessee be the last sentence, page 58, last sentence, the state government on receipt of application for renewal
shall consider
it in accordance with Rule 12 of the said rules, and shall pass orders as it deems fit. If renewal is granted, such and such. Now, if Rule 12 is not there, what happens to this? By contract, can you revive a deleted rule?
No, I am saying, my lord, that my right in terms of Rule 12 is protected for a period of 5 years plus 5 years. Now, state government, my lord, today enters into an agreement with me. My lord, tomorrow, my lord, it decides that the law has to be altered. It alters the law, and in the process, my lord, my right gets evaporated. My contractual right gets evaporated. That is
contractual right remains, but there is a specific reference to a rule.
Lord, insofar as this is what is the division bench judgment, which says that my contractual right, that survives, and the contractual right is in consonance with Rule 12, which exists as on the date, when I entered into the agreement.
All right.
That the state government, that government would act, in fairly and not unjustly. ABL International,
private contracts.
ABL International, I am not citing before, my lord.
Yes.
And there is no retrospective operation insofar as my application for.
Your application was filed after 2016.
Yes, my lord, that's
no question of retrospective.
Yes.
But it does not take away. It does not take away, my right, which has accrued in terms of the contract.
60-2.
My lord.
60-2. Yes.
Well,
ABL you can formally cite, Mr. Chaudhary. Since you have brought it, why not cite it? You have taken the trouble of taking out, your junior has taken the trouble of taking out photocopies. You have gone through it again for the 100th time.
But in fact, I was only citing the judgment.
Oh, cite any one judgment on that proposition.
The judgment which I indicated to my lord, I thought that this is only relevant. But ABL was cited in another like matter, before another. My learned junior said that should
legitimate,
be
legitimate expectation.
Paragraph.
Yes, give us the paragraphs.
Paragraph 8, 10, and 23.
কি citation টা কি আছে?
2004 volume 3 SEC 553.
2004
volume 3 SEC 553. Enforcement of contractual obligation by filing rate petition.
Even in contractual matters, state has to
My lord.
maintain that standard of fairness.
My lord. And I can file a writ petition to enforce contractual obligation.
Yes, yes.
My lord. But my learned friend already narrated the facts for granting lease. The lease was for 5 years.
Yes.
But it is ended on
26 March
26 March 2017.
Yes.
Now, my learned friend, my client, filed the application on 31st August 2016.
Yes.
And in the writ petition, nowhere in the averment says that yes, we have deposited 500 rupees as required under Rule 12. And they have only they have mentioned this.
In accordance with law.
Yes, only paragraph 6, they have just indicated that. The 2 lines I'm making. Your petitioner took position, sir. Your petitioner made an application dated 31st August 2016 for renewal of the same in accordance with law. But the learned judge did not find any, the challan was not annexed and no averment to that effect. As such, the learned judge passed this order. But even your lordship might kindly see just now your lordship correctly pointed out that so far as the lease is concerned, there is no dispute. And so far renewal is concerned, but this act came into force on 29th July 2016.
Yes.
And after repealing these 2002 rules, he made an application for renewal on 31st August, when there was no existence of Rule 2002. But now, if you kindly come to page 58 on second, Madam Lordship, page 58. And last paragraph, page 59, it is mentioned that this renewal to be considered in terms of Rule 12, in terms of minor measures 2002. So when 2002 rule did not have life on the day when the application has been made, then there is a question of consideration in terms of Rule 12 of that Rule 2002 cannot and does not arise.
Yes.
Now, my learned friend mentioned that he has a right. Yes, but renewal, now you also fell from the page 58, that it is the discretion. They have just made an application, but that was not either rejected nor consideration. There is a question of rejection. So, my learned friend says that question of rejection does not come since the application was not considered at all. Now, the question of other provisions for rejection does not arise. And if your lordship see that the order, once again, the impugned order, page 75.
Yes, we have seen that.
Yeah, lordship.
2 grounds.
Just 2 grounds.
500 and
500,
2016.
yes, 500. Even though there is no averment in the writ petition as against the payment of 500, nothing there, source. And must also just mentioned that the rules come into force on 29 July 2016, and that was application after that. So, even during the survival of the Rule 2002, this application was not made. As my submission to before lordship that when the rule itself was not.
What about their Mr. Chaturvedi's submission that it was made in terms of the clauses of the contract itself, contractual right?
But contextual right, contextual right mentioned
gives
in
him the right to
yes, but contextual
forget 12.
but contextual right renewal contract is there in the lease. In the lease, they have mentioned the renewal clause. Clause 3, renewal clause.
Why can't they enforce this?
Well,
forget about 12. The 2002.
No,
clause.
yes.
Why not on the strength of this renewal clause they can
But
apply?
renewal clause is there. Renewal clause, it was said that this renewal clause to be considered in terms of Rule 2002.
So therefore, since that is not there, this renewal clause you say is meaningless.
Yes. Obviously, obviously. But and renewal does not create any right to give renewal to the parties.
No. There, that
Yes,
is
this-
it is
yes,
premature
yes,
to say so.
yes.
Learned trial judge, learned single judge dismiss their application for consideration of their application.
Yes.
So we cannot decide on the merits of
Yes,
that. You have that right, and if you reject that, they
Yes,
have another cause of action.
They
faced
should
for it.
come later, madam.
Later, yes.
Later, just whether
So let us pass our judgment now.
as you're not sure.
Lord, only one thing, Lord, may I? Lord, this.
And also, the judgment cited, but it is based on 2002 rules.
2011.
11 amendment. 11 amendment.
Yes, Mr.
Yes.
That page 58, what my lord indicated, was taken note of by the Honorable Division Bench, the coordinate bench. At page 20, my lord would very kindly find.
That is 2011 amendment. No?
I'm referring to page 58 of the paper book, my lord, which says clause 3.
Yes.
Any part or whole of it can be refused. This was considered by the coordinate bench at page 20.
Yes.
My lord would very kindly find the first paragraph. In this regard, I would like to mention here that first of all, since the amended rules were not given retrospective effect, it was introduced with prospective effect. The right which was accrued in favor of the petitioner to have the lease renewed as per the terms of the lease deeds cannot be nullified by applying the amended provisions of said rule. To clarify this position, I feel that the relevant clause.
What we observed that has been held here. We said that proviso, that second paragraph, that is also circumscribed by the subsequent things.
Yes, and
that if they receive an application, they have to consider in terms of in accordance with Rule 12.
So, Lord, that
that is circumscribed by this. They can reject because after considering it in accordance with 12.
Yes,
that is provided in that clause itself.
The entire or a part thereof. So they have to consider in terms of the old rules and then to come at a decision.
Yes. There is a question of rejection because we have not considered this.
That is what I am saying.
Yes. And unless just government said that since rule has been repealed,
the present order, the present appeal arises out of an order dated August 29, 2017, passed in WP 8784 within bracket W of 2017. Full stop, next para. By the said order, comma, the learned single judge dismissed the writ petition of the present appellant, which was filed seeking a consideration of the application for renewal of a mining lease given in favor of the petitioner under the West Bengal Minor Minerals Rules, comma, 2002. Full stop, next para. While dismissing the writ petition, comma, the learned single judge observed that there was nothing on record to indicate that the petitioner had deposited requisite fees of rupees 500 with the district magistrate Burdwan for consideration of the application submitted by the petitioner under the provisions of Rule 12 within bracket 1 of the 2002 rules. Full stop, that apart, comma, the learned single judge held that the said application for renewal made by the petitioner under the old rules of 2002 was no longer maintainable, comma, since the said rules had been repealed by Rule 62 of the West Bengal Minor Minerals Concessions Rules, comma, 2016, which had come into force prior to the renewal application being made by the writ petitioner stroke appellant. For some next para, learned senior counsel appearing for the appellant argues that the reliance of the learned single judge inter alia on Rule 61 of the 2016 rules was misplaced, comma, inasmuch as the said provision contemplates original applications for grant of mining lease in the first place and not renewal applications. For sub next para, learned senior counsel places particular reliance on Rule 12 of the 2002 rules, comma, which provides for renewal of mining lease. Full stop. Rule 8 within bracket 2 of the 2002 rules categorically provides that an application for grant or a renewal of mining lease shall not be refused by the state government or the officer so authorized by it only on the ground that the application is not complete in all respects or is not accompanied by the required documents. Full stop. Next para, learned senior counsel contends that the appropriate governing provision of the 2016 rules would not be Rule 61 thereof, but Rule 62. Full stop. Rule 62 within bracket 1 provides that the 2002 rules were repealed. Full stop. However, comma, subsection 2 of sub-rule 2 of Rule 62, comma, which starts with a non-obstante clause, provides that any action anything done, comma, any action taken or any prosecution started under the 2002 rules would be deemed to have been validly done or taken or started, as the case may be, under the corresponding provisions of those rules. Full stop. It is argued that since the mining lease was granted to the petitioner stroke appellant under the 2002 rules, comma, which itself contained a renewal clause, comma, the said grant of lease, comma, including the renewal clause was came within the purview of within double inverted anything done double inverted clause and double inverted এর মধ্যে any action taken under the 2002 rules and comma thus comma were saved by rule 62 within bracket 2 of the 2016 rules. Full stop. Next para, learned senior counsel argues that in view of Rule 8 within bracket 2 of the 2002 rules, comma, the mere technicality of non-deposit of rupees 500 would not vitiate the renewal application itself. Full stop. Next para. However, comma, learned senior counsel submits that in the present case, comma, there was no occasion for the learned single judge to come to the finding that the petitioner had not deposited the requisite fees. Full stop. It is contended that the learned single judge prejudged the issue, comma, since at the threshold, comma, even before direction of affidavits, comma, the writ petition was dismissed on the assumption that there was no document which was annexed to the writ petition to show that the requisite fees were deposited. Full stop. Next para, learned senior counsel places reliance on paragraph 6 of the writ petition, which carried the categorical averment that the petitioner stroke present appellant had made an application on August 31, 2016 for renewal of the lease deed granted initially on May 4, 2012 within double inverted in accordance with law, double inverted clause, comma, which takes into consideration the provisions of Rule 12 within bracket 3, comma, which mandates the deposit of rupees 500. Full stop. Next para. Hence, comma, in the absence of any objection thereto, comma, since no affidavit in opposition had been invited at that stage, comma, the learned single judge erred in law in observing that there was nothing on record to indicate that the compliance of the deposit of requisite fees was not done by the writ petitioner stroke present appellant. Full stop. Next para, learned senior counsel places reliance on division bench judgment of this court reported at 2014 SCC Online Cal 13995, where the coordinate bench was considering the effect of 2011 amendments to the 2002 rules. Full stop. Next para. While deciding so, comma, the coordinate bench had made certain observations which are pari materia with the considerations before this court. Full stop. Next para. Learned senior counsel places particular reliance on the observation of the said division bench to the effect that even assuming that the amended rules were valid, still then the decision for rejection of the petitioner's application for renewal, comma, taken by the competent authority, comma, could not be supported. Full stop. The division bench observed that first of all, comma, since the amended rules were not given effect retrospectively and it was introduced with prospective operation, comma, the right which was accrued in favor of the petitioner to have the lease renewed as per the terms of the lease deeds could not be nullified by applying the amended provision of the said rules. Full stop. The renewal clause, comma, it was observed, comma, makes it clear that the lease is renewable at the option of the lessee, and if a lessee is desirous of taking a renewed lease of the premises or any part thereof for a further term of 5 years, then he is required to apply for such renewal before the concerned authority prior to expiration of the term of the lease by giving 6 calendar months previous notice in writing to the state government. For sub next para, it is contended that going by the proposition laid down therein, comma, even if the 2002 rules were deemed to stand repealed on the relevant date when the renewal application was made by the present appellant, comma, by virtue of clause 3 of the lease deed itself, comma, the appellant had a right of renewal at his choice. Full stop. Next para. Hence, comma, it is argued that the learned single judge erred in law in rejecting the dismissing the writ petition without directing the respondent authorities to consider the